Yes.
one matter for which, my lord, we have already discussed the matter with my lord relating to that notification, which is supposed to be 2nd of April, second week of April. That matter is pending, my lord. Even now the circuit bench is also.
We gave a date for that matter. It was adjourned.
We are saying about that notification which was already 26th of November already held. A group of matters is pending, my lord, regarding the ground.
You give the number, let us list.
No, the senior ground matter which is supposed to be held at the collegium.
Senior designation. Now the problem is we have to amend the rule because of the recent decision of Supreme Court.
Well, that decision we have gone, that is not affected the particular.
No, now it has become much simpler. So what I have done is, we are now preparing a brief and which are the things have to be deleted from the rule and the new procedure has to be. Give us some time.
No, Para 80, sir.
Regarding that.
I'm sorry, Malad, I'm too small to speak on this issue. A paragraph is there which says this judgment will not applicable to the pending matters.
That is it.
We have marked that paragraph.
Okay.
And probably my senior friends have already given it to.
Then we will constitute the committee once again. At the earliest.
As soon as possible, Malad. Otherwise, because of the issue of circuit bench, 12th July will not happen. Some other date will be fixed. In the meantime, Malad, if
I'll do something.
Grateful.
May I have Lordship's kind indulgence to mention one matter, Lordship, with regard to recalling application I have filed pursuant to order which was passed on 16th of June. My Lord, the matter is a Group 7 matter. We have filed the writ application. It was disposed of in 2022. Thereafter, my Lord, appeal was preferred in the year 2024, projecting it to be a Group 3 matter. Now, it went before the Honorable Coordinate Bench of the Honorable Division, and they said they granted liberty to correct the cost title.
But presentation
it was again, my Lord, done as Group 6. Now, on the basis of that, my Lord, order.
Show the order.
Order, my Lord, I filed a recalling application, my Lord, and also there is a delay of 700 days. That was also not indicated before your Lordship. And referring to be mentioned, my Lord.
Here, give the number.
Last week I have mentioned myself, Sangeeta Chakrabarti, due to some urgency and extreme situations, sir, I came to you, my lordship. My organization name is, I'm a human rights activist, and my organization name is SS Human Rights Foundation. And the Vice President is Sujit Mukherjee submitted 3 writ petition against the ruling party's member, the MLA Jafikul Islam Domkol, WPA number 12207/25, Chairman of the Baharampur Municipality, Noni Gopal Mukherjee, that is 136693/25, and the Rajiv Hossain 14469/25. 3 writ petition is submitted. Right now, sir, we are in huge fear situation. Some sharpshooter is appointed to kill both of us and the few police officials. I see Domkol, I see Baharampur police station, I see cybercrime. Close my Facebook account, which is 40,000 people are there. Last 12 days, we are in huge fear situation.
This writ petition has been filed as a PIL, is it?
Sir, I make a petition today because take it as a suo motu cognizance, or sir.
Suo motu cognizance can't be taken. You file a petition. If it is a public interest, it will go before a division bench. If it is in your personal name, it will go before a single bench. You file a petition.
Okay, sir. Sir, leave application can be granted.
No. First, prepare the petition.
Okay, sir. Okay.
Last week I have mentioned this matter. I filed to memorandum application without certificate copy, Lordship. Your Lordship directed to apply it, and I'll give direction to within as soon as possible. Certificate copy will be provided, but file could not be traceable before the mandamus, Lordship. So
not traceable.
No, Lordship. I'm praying for only with server copy to file at memo application, Lordship.
What date of the order?
2022, Lordship.
But then
there's a delay. I have already everything is prepared, Lordship. That memo file has been without certificate. I cannot file this memo, Lordship. And file could not be traceable, so I could not file any delay application. I went to the mandamus before the DR, Lordship.
You give the letter. Let us find out from the department whether the file is not traceable.
I went there, Lordship. They called me.
We have to verify, madam. You please give. Yes, please call.
Original say daily list, item number 1.
One and two, both. Yes. You first read the book. Last two paragraphs.
39. In view of the above, the appeal filed by the ECL being APOT number 106 of 2025 is dismissed, and the appeal filed by the petitioner claimant in APOT number 123 of 2025 is partly allowed. The impugned order passed by the learned single bench is modified as follows. The area of monetary compensations to be paid on and from September 2001, when the committee was of opinion that the authenticity of the claim instead of the date of death of the deceased employee, along with simple interest at the rate of 7.5%, and such payment is to be made on or before 15th July 2025. The other observation of the learned judge is to remain unaltered.
Then your lordship is allowed MMCC from the date of death without interest.
Not date of death. That is
Date on which the committee.
that decision. When the committee was of opinion, that is September 2001.
September 2001.
Area will be paid from September 2001.
2001. Just a month's difference probably.
You send it to the chamber, then one copy is enough, no? One is enough.
Thank you.
Yes, next.
I'm good.
To be mentioned, item number 3.
For the appellant, my lord, in this matter, if your lordship kindly recollects, your lordship has heard this matter from time to time. And on the last occasion, my lord, if your lordship also kindly recollect, it was an undertaking was given by the respondent that they will not proceed before the learned tribunal. In spite of such undertaking given before lordship, the respondent has filed an application and proceeded before the learned tribunal, and the learned tribunal has chastised the department. Learned tribunal has fixed the matter tomorrow, and has further asked for personal presence of the concerned officer before the learned tribunal. In such circumstances, lordship, I beseech your lordship to stay the proceedings before the learned tribunal and kindly fix up any day subject to your lordship's convenience on any day and hear out the matter.
The petition was filed way back, about a month back.
But then
I stated that I won't proceed with the matter. What my lord, I am saying I will withdraw the application, my lord. There is nothing. What was being said to the court when my learned friend mentioned the matter, where we said that we only drew the attention of the tribunal to the order passed by this court on January 3, 2025, when this court was of the opinion that these goods may be released when the burden adjudicating authority himself has held that I have discharged my burden. And only in that circumstances.
There are certain orders, we don't make written orders, we make a request.
Yes.
If your authorized representative has not been communicated with what transpired here, probably we will show him the video footage of what transpired in court. This is unfair. This is unfair.
So
it won't take us even 3 minutes to stay the proceedings. We didn't want to do it.
No, I withdrawing it.
Many a times, Mr. Mehta, many a times,
yes,
contempt petition is filed before the single bench. Appeal is filed before us.
Yes.
So we request the counsel for the contempt applicant, please defer the hearing. We will fix the matter in a day or two. That gentleman agreement is there. They go for the single bench and take it. That was what the understanding. A senior counsel is appearing, and Ashwin Chowdhury, who appeared for them, he said that neither stay has been obtained by the revenue.
But that is previous one. But that is not yesterday.
No, that is the last order, my lord.
It is the last order.
Last order. Yesterday's
2nd
order.
July, the revenue officer has been summoned. Then what for we are sitting here? Please give the file.
My lord, what I am submitting.
You will not get the gold. You will not get it for the next 2 years. Take it from us. As if things are perishable. We always balance the interest of the assessee as well as the department when it comes to interim orders.
Yes, my lord.
And senior advocate is aware of it.
Yes.
You have been appearing almost for 4 years after I have come here.
Yes, my lord.
So we have, in fact, yesterday also in Jalpaiguri matter, we convinced the revenue that the vehicle cannot be detained. It's hurricanate, it's a perishable item, it needs to be sold. Your interest will be protected. You will participate in the auction, which suggestion did not even fall from the counsel who appeared for the SSC. See, that's how the court balances.
Yes,
Sir, I am not new to this revenue field.
No, my lord.
Okay, 16 years plus 16 and a half years plus this side. As you are very well versed with revenue for more than 30 years that side. So therefore,
what happened?
We are disappointed, sir. We are disappointed by what Mr. Ashwin Chaudhary represented.
And what I am submitting is this. I will withdraw this application. I have instructed my learned.
You can't withdraw this order. You can't withdraw the order. Asking the revenue officer, concerned revenue officer, to be personally present for the tribunal. How can you withdraw this order? You show him a copy.
Just have a look.
Last mail.
Sir, please come, sir. Reference may be made to the order dated 19th April 2024, which is quoted here and below. In terms of the above order, the appellant department was directed to release the silver granules mixed with white color coins and 20 pieces of gold guinea to the rightful owners, as mentioned in paragraph 64 within bracket small b of the order passed by the adjudicating authority, to the rightful owners on an application being made by the said owners to the respondent. This direction was issued as the appeal filed by the department against this direction of the adjudicating authority was dismissed, and as against the same, the department did not prefer any appeal to the tribunal. Therefore, we affirmed the said direction, and the direction was directed to be complied with within a time frame. We are informed by the learned standing counsel for the department that this direction has been complied with. Thus, the other aspect is for release of the gold, which is in the custody of the department. Gold and currency. Since the appeal has been preferred against the order of the tribunal, and certain substantial questions of law have been and the following substantial questions of law have been raised by the department, which requires to be considered, we are inclined to admit the appeal on the following substantial questions of law. Page 37, 38, A to G. Full stop. On the last hearing date, when the matter was mentioned on an earlier occasion, we were informed that an application, miscellaneous application, has been filed by the respondent herein before the learned tribunal in Customs Miscellaneous Application 75363 of 2025, wherein certain directions have been sought for release of the gold and currency. The court orally made an observation to the learned senior advocate appearing for the respondent that the application need not be pressed for the time being, since this court is inclined to take up the appeal at an early date. However, it appears this broad understanding was not recorded, as the court was of the earnest belief that the same will be conveyed to the learned advocate / authorized representative who will appear for the respondent before the learned tribunal. However, we are surprised to note that the authorized representative of the respondent had made submission on merits before the learned tribunal when the application was heard on 30/6/2025, and a direction has been issued to the concerned officer of the revenue to remain present on 2nd July 2025 to apprise the learned tribunal as to whether they have obtained any stay order against the order passed by the tribunal or complied with the order passed by the tribunal till date or not. Considering the fact that we have admitted the appeal, the order passed by the learned, the impugned order in the appeal passed by the learned tribunal, as well as the order passed by the learned tribunal in Customs Miscellaneous Application 75363 of 2025, dated 30/6/2025, shall remain stayed until further orders. List the appeal for hearing. Since all the necessary documents are available in the stay petition, filing of informed paper book is dispensed with. Let the appeal be listed for hearing on 15th July, immediately after fresh cases. Next.
But only one humble submission, Lordship, let the tribunal act upon the letter issued by the learned advocate and record, because in case we do not get the...
We'll get it, sir. You get it now.
I'm grateful to your Lordship.
Item number 4.
I'm sorry, my lord. What I instructed didn't percolate. I had when this percolate. I'm really, my lord, very sorry.
3, 4, 5, 6.
3, 4, 5, 6.
At times we go.
My lord, yes.
We take steps to convince the revenue.
Yes, my lord. I have said.
Mr. Mehta is not new to this.
Yes, my lord. I've instructed my junior.
We always feel that the department doesn't stand to benefit by holding back articles. But here the issue is whether it is of Indian origin or foreign origin. You have got a good case, you have succeeded before the tribunal. So, therefore, what should be advised by the counsel on record to the client is, please wait for your turn. And if he is so very... And we can read in between the lines also.
I'm really sorry, but this is really, this is really not.
And I had
said this in many words.
No. What can the officer of customs do before the tribunal?
I appreciate.
Go stand with folded hands. Sir, my counsel is asking for early hearing of the appeal. Appeal has not been heard by the court. Stay order, stay petition is also pending. Is all that he can say.
Yes, that is all. That is. I'm really extremely sorry for this.
No. You need not be. As senior counsel, you are immune from all.
No, I'm not immune. My junior was there. He had come from all Lucknow from this, and so I have told him that court's desire was you will be taking adjournment sine die, and that's all. And
it won't be. It won't be. Therefore, only we place the matter under the caption to be mentioned so that something can be done. Anyway,
but
on 15th July, we'll hear you.
Yes, my lord. But really, it's bad. I also feel bad, my lord. What has been done, my lord? This by
my lord, I bow down. I bow down in apology. I was unaware of whatever happened in between. I am a transplant patient. I underwent a renal
Don't
transplant.
strain yourself. Nothing will happen. In fact, the value will increase.
My lord, I bow down.
Thank you. Next.
Grateful to your Lord.
Tax matters, item number 7.
Sure.
There is a delay of 187 days.
What is this reopening? Is it?
No, reopening. 263.
260.
My lord, regarding the...
So today we will condone the delays as it is. There is a delay of 133 days in filing the appeal. As the explanation offered is acceptable, the delay in filing is condoned. Application is GA1 of 2024 is allowed.
Item number 8.
8 and 9.
8 and 9, both have, it has come back.
Refused.
No,
address he left without intimation.
Then fresh notice to the correct address.
Email notice.
And who appeared in the tribunal?
Tribunal.
Mr. S.M. Surana appeared.
Yes.
Pardon?
He will inform.
You can also inform.
I shall also inform.
Since the notice sent to the respondent has returned with a postal endorsement, address he left, let fresh notice be sent through email, and also and also the learned advocate who appeared for the respondent before the learned tribunal may also be informed. 2 weeks. 8 and 9, same order.
Item number 10.
My lord, this matter, my lord, with a delay of 45 days,
Milord, kindly, Milord, condone the delay and
That can be condoned. What is the matter about?
not very good.
Hmm?
Not very good for me.
Let us see the file. IT 123.
জায়গা থেকে টাকা পেয়েছি আমার যেটা দাও গাড়িটা দাও এইটা যেটা দেখাচ্ছে হ্যাঁ জায়গা থেকে টাকা পেয়েছে একটা সেই জন্য একটা দিকে আগে রিলিফ দিয়ে দিই 4 কোটি কত টাকা
হ্যাঁ, CIT appeal.
2 কোটি কত টাকার এগেনস্টে অ্যাসিসি অ্যাপিল করেছে সেই অ্যাপিলাতে অ্যালাউ হয়ে গেছে
All right, please come. There is a delay of 45. We have heard sounds. There is a delay of 45 days in filing this appeal. As the explanation offered for not preferring the appeal within the period of limitation is acceptable, some of the delay is condoned, and the application in so and so GA is allowed. Para. This appeal has been filed by the department, Income Tax Department, under Section 260 Capital A of the Income Tax Act 1961, within bracket the Act, challenging the order dated 18/10/2024 passed by the Income Tax Appellate Tribunal C Bench Kolkata, within bracket tribunal, in ITA number 245/KOL/2024 for the assessment year 2011-12. The revenue has raised the following substantial questions of law for consideration. Page number 12. Question number 1. Page 13, question number 3, 2 not required. And question number 4, page 14. After elaborately hearing the learned advocates appearing for the parties, we have perused the orders passed by the Commissioner of Income Tax, by the First Appellate Authority, as well as the impugned order passed by the learned tribunal. The issue which falls for consideration is whether the reopening of the assessment was valid. The learned tribunal has taken note of the facts and has pointed out that the assessing officer has not applied his independent mind to the information received from the DDIT, all capitals, within bracket investigation, Kolkata. As the information received was extracted in the reasons recorded, as they were received even without verifying the same, whether those were correct or not, and the assessment was reopened under Section 147 of the Act. Furthermore, the learned tribunal has pointed out that the assessing officer has not verified the facts, as there was no unsecured loan raised by the assessee from Messrs. Sadabar, SADABHAR Commodities Private Limited. Further, the learned tribunals pointed out that the name of the assessee has also been wrongly known.
He has not done
Thus,
anything wrong. The department is wrong.
thus the tribunal on facts concluded that the reopening of the assessment was bad in law. We find no justifiable ground to upset the finding recorded by the learned tribunal, which was rendered upon reappreciation of the factual position. Apart from that, the learned tribunal has also found that section 133 capital C within bracket 2 of the Act, which was inserted with effect from 1/6/2016, has no application to the assessee's case. Thus, for all the above reasons, we find no good grounds to interfere with the order passed by the learned tribunal, and in particular, we find no question of law, much less substantial question of law, arising for consideration in this appeal. Accordingly, the appeal feels dismissed. Next.
Obliged, my lord.
Item number 11.
As I'm for the responding minutes. The tax effect is 29 lakhs and a half minutes.
Because of penny stock.
Addition under section 68, my lord, the accommodation.
As
So it is under the exception clause. My lord, the finding of the tribunal is page 27, para 6. Starts there. The tribunal held that the reopening is bad. Since the assessing officer did not apply his own mind, he acted only on the basis of the information received from the investigation team. Cool.
Yeah, also.
Apart from no independent application of mind, the tribunal says
yes, ma'am,
that they had placed all the details of the income tax return, MCA, master data, etc. for the year 8-9. Form 2, return of allotment of subscription. Director of the assessee appeared before the A1 in compliance with the summons.
Minutes.
What is there?
my lord, but the addition was not made on that the identity. Here, my lord, the assessing officer held that the investor was asked to, the assessee was asked to explain the source of source from where the investor not made. But that explanation was not given by. That's why the assessing officer made addition. My lord, can you come to page 14? However, on examination of replies received from notice under section 133(6) and summons under section 131 on recorded statement, it is seen that one Sri Prakash Kumar Damani and Sri Rajkumar Damani stated to be the directors of Damani Polymer, Sake Traders, respectively, have failed to substantiate the source of capital invested to the assessee company for purchase of shares with premium. In the statement recorded, why question number 9, explain the source of fund which have been invested in share of Krishna Nirman. The directors of both the companies have answered that the source of fund was invested received from other companies. When asked to asked the evidences on such transaction, the directors are remained silent on this issue. Even has failed to produce the name and addresses of the company from whom such money is received. And my lord, there was no justification given for charging a premium of rupees 90.
That is
Premium of
rupees 90 on face value of
There's
10.
only rupees 90, my lords.
90
And
is
that
at
too, my
20.
lords, this is a group company, my lords, where we have issued. In fact, my lords,
The
there
assessment
are
year 2008-9, my lord.
the shares have been allotted to 3 entities, one individual and 2 entities. The addition has been made.
But appeal was dismissed for non-prosecution before the CIT appeal.
CIT appeals, my lords.
And my lord, this on reopening, my lord, borrowed satisfaction, no, my lord, judgment is PL going.
On facts, we have held in your favor, department's favor in a lot of matters. But
As there is no independent inquiry that was conducted, as 131 and 133(6) compliance was also there, my lords. As
How it can be said that no independent inquiry was made by the assessing officer. When the assessing officer is taking all the steps in this paragraph 9 to 12.
But the three persons in whose favor the shares were allotted, they are all group companies.
Two companies, one individual. The addition has been made in the respect of the company.
Yes, Dhamini Polymers,
Yes,
Saket Traders, and Abhishek Kothari.
Yes.
And
but
there are
the
common
addition
directors.
has been made only in respect of these companies, not in respect of the individual.
that is true, sir.
Yes,
but then you recorded some statement from the directors of Dhamani Polymer.
Yes, my lord.
Was it
And
put
also-
to the SSC? That statement should have been furnished to him, because they have appeared in response to the summons under 133(6). Statement has been recorded, which the assessing officer accepts. And before the commissioner appeals, they have said they produced all the records.
My lord, the explanation source of source that can be explained by the investing companies, and they were asked for that, but they could not explain.
Did you give a reply to the reasons recorded for reopening?
Yes, we have given, my lords. Today, I was actually briefed in this matter, and there is also a delay, my lords. My lords may condone the delay. This matter may
Then
be
you
taken.
do one thing: you file a small compilation containing the reasons for reopening, your reply, and the what was the order passed? This was under 148 AB, is it?
My lords, it is the previous law, my lords.
under
148
the-
notice directly.
And he would have passed an order under 148.
My lords.
That copy, and your grounds of appeal before the CITA as well as before the tribunal.
My lords, I'll do that, my lords.
We have heard so and so. There is a delay of 119 days in filing the appeal. As the delay has been properly explained, the same is condoned. Application in GA 1 of 2025 is allowed. Next para. The learned advocate appearing for the respondent SSC is directed to file a compilation containing the reasons for reopening, the reply/objection submitted by the SSC, the order passed by the assessing officer under section 148 of the Act, the grounds of appeal filed before the Commissioner of Income Tax within bracket appeals, as well as the grounds of appeal filed before the learned tribunal. 2 weeks time.
Item number 12.
My lord, I'm appealing.
Upon the respondent,
My lord, there is a delay of 199 days.
I'm not opposed.
The learned tribunal says the order passed by CITA is a non-speaking order.
Yes.
Impugned order is also a non-speaking. What
This
they
make-
could have done is, either they could have directed the assessee to file a paper book,
Yes.
and they could have heard out the matter on merits, or they could have sent it back to the CIT. They
So-
quote 3 judgments, Manish, Bildwell, etc. And then ultimately they see, you come to page 44, last 4 lines. Perusal of the impugned order of the learned CITA shows learned CITA has not discussed anything about the material facts. He has not pointed out any defects, discrepancy in the evidence furnished by the assessee. Simply upheld the order. His non-speaking order, same is unsustainable. In view of the above discussion, we'll send it back to CITA.
My lord, may I come back on?
Your client won't agree, sir.
My lord,
Don't rely on
let me go through the tribunal's order and everything. My lord, yesterday just received the brief. My lord.
No.
My lord, kindly.
If it goes to the tribunal,
Yes.
you won't get the appropriate relief. Let it go to the CIT.
My lord, may I come back on next day? My lord, then my lord, kindly.
All right. We have heard so and so. Delay condoned, sir. 199 days.
Great. My lord.
For admission of tax matters, item number 13.
Good, I'm appearing in this case. But on the basis of DDIT investment, and for my lord's convenience, I've prepared a list of dates because this is actually the third or the fourth round of the proceedings, with one round already having been concluded before my lords. On the basis of a DDIT investigation, my lord, reopening was made on the ground that the SSC companies involved in case of accommodation entry, my lord. The huge amount was, my lord, to more than 2 crore. Lordship will kindly see the assessment order. Lordship will find, my lord, page number 9, assessment order, my lord. My lord, on the basis of, with this regard, 147, the credible information was received, such and such, by that the Mrs. Pearl Telecom Limited was having current jurisdiction with this, has taken accommodation entry and brought back its unaccounted income to the tune of rupees 2 crore such and such in the regular books of accounts bearing number sensor through Mr. Sandeep Roy, proprietor of Sarika Trading Limited, a shell company. As per the observations of the investigation wing, the cash deposited in the accounts of the fictitious entity and simultaneously followed by debits of the to the various accounts. These accounts have been frequently been used for layering the funds through the several bank accounts of the Jamakhachi shell companies and immediately transferred to the interlinked bank accounts and then ultimately to the bank accounts of the concerned beneficiary. Milord, if your lordship kindly come to page number 11, Milord, he was summoned, Milord, and Milord, 131 notice was also issued to him. But page number 11, your lordship kindly sees, Milord, Mrs. Last paragraph. As per the information, Pearl Telecom has taken accommodation rate to broadband account income of rupees 2 crore 48 lakhs to the regular books of accounts through banking channel of Mr. Sandeep Roy. Mr. Sarika Trading Company, a proprietorship firm, having current account with the Mission Road branch, such and such. Inward, Mr. Sandeep Roy, proprietor of the firm. The business of the firm is said to be a grain supplier. The pattern of the transaction of the account laid by is a large value of credit received through RTGS from the various accounts of the Mrs. of Jasmine Enterprises and Ankit products and such, my lord. The credit of was received are immediately transferred to the various current deposit accounts of the branch of that is, my lord, Lakshmidhan Distributors, my lord, Salasar Garments, the other Dhara suppliers, such and such, my lord. There is no common business relations found as per the branch observations. All the in all the above accounts and hence it seems that the huge funds are just routed from the account of another without any automatic rotations. Besides this, there is a large value round amount cash was deposited in the account, followed by a debit by way of a transfer to the above mentions accounts, current account of the same branch. Most of the deposits have been below such and such. But during the current year, financial year 2012-13, a credit or debit turnover to the tune of rupees 4.73 crores and 4.72 crores, nearly 40% of the total credit turnover by way of a cash deposit. Not all these transactions without any economic relations with good suspicion. Thereafter, 131 notice was issued. Matter has been investigated, and on examination of above mentions, it shows that the deposits in the account of was an ultimately followed by the details of various accounts. So it is found that they are depositing the amount, and subsequently the amount was credited to different companies. There is no connection. That's why and huge cash was deposited. So it was that there is the business of accommodation entry. If your lordship will kindly see the CIT's observation, that is also there. If your lordship will kindly come to straight away, CIT's observation, page number 66. Ground number 4. The learned AO the learned AO erred in the facts and was making a sum of rupees. Upon going to the matter of record, I find that the assessing officer was in possession of information from the investigation that the appellant had been the beneficiary of the fictitious transactions through Jamakhatchi companies. This had been done through one Sandeep Roy, the proprietor of Sarika Trading, amounting to rupees 2 crore 48 lakhs during the financial year 11-12. These transactions were laid to be nothing but accommodation entry provided to the appellant who served as a beneficiary. The appellant, I find that offered no explanations nor clarification to the information during assessment proceedings, despite specifically and repeatedly asked about it, and both during the assessment and the remand proceedings. Notices were under section 133(6) were issued to Sri Roy, the person who provided the accommodation entry. There was, however, no response from that quarter. Since the appellant had contended that he was not provided with a reasonable opportunity to rebut asserts the assessing officer, the appellant was provided with the opportunity through remand. The remand also, there was no explanations offered by the appellant. He could neither produce Sri Roy nor intended to the Sri Roy respondents to the notice of the assessing officer. In this regard, the assessing officer during the remand report has noted the AO in the instant case has issued under section 148 on such and such date wide DIN number asking the assessing company to furnish the return of income under section 148. The AO obtained the requisite approval from the PCID 4 Kolkata, the prescribed authority. Thereafter, the notice under section 142(1) was asked to the assessee companies such and such, and thereafter the show cause notice was issued to such and such. In reply to the notice dated 14/10/2019, the assessee furnished a copy of balance sheets only. Further, wide submissions dated 3/12/2019, the assessee submitted ITR 5 balance sheets, bank statements. Subsequently, the assessee company filed a letter and requested for providing a reasonable reasons for recorded initiation of a reassessment proceeding under section 147. In reply to the same, the AO furnished the same wide dated such and such. It is also asked the assessee to company to furnish the reply show cause. However, the assessee failed to reply the show cause notice dated 15/11/2019. Even after giving 1 month's time and the reminder, the AO passed the assessment order making addition of rupee 2 crore 48 lakhs. The AO assessing officer has issued 133(6) to notice to Sandeep Roy of proprietor Sarika Trading Company for verifications of the transaction. The said notice was not been replied by the said party. Non-compliance of the party clearly states that the allegations are true, and hence there was no question of on the basis of behalf of the AO assessing officer has already put his mind and informed the reasons believe. He has also concluded the inquiries by issuing notice under section 136. Hence the assertion of the SSC is void of merit. The appellant has also been able to has not also been able to file any form of cogent reply to the above observations except the transactions without providing any details regarding the transaction itself. I find that it has been brought to the light through the wing during the assessment that such funds as were considered the accommodation entries were routed through the channel of several layers for which the appellant could furnish no reply. The common knowledge that the modus operandi has been followed by several Jamakhatchi accommodation entry providers. It is settled principle the law that the initial owners for providing proving that any of all these transactions entered into by him are genuine and not bogus lies upon the assessee. The owners needs to be discharged through production of the evidences and through affording the of a reasoning. This exercise has not been completed by the appellant. He has nowhere denied the transaction,
This
but
man, I
merely,
would want to
but he has,
emphasize
this is
that
the
this
Malad
is a
detail.
this is a contradictory statement because he's constantly been recording the fact that I've denied transactions. Now he's recording here, the assessee has nowhere denied the transaction. And then again, my lord, he contradicts
No,
himself.
no, see, first time assessment order was passed.
Yes.
And total income was assessed at about 79 crores.
My lord. My lord.
That was in March 2015.
Yes.
Then in 2016, 263.
My lord.
But did you file an appeal against this?
My lord,
to the CIT appeal?
My lord, if I may give the entire factual background, my lord, in what has happened in the matter, if my lord may allow me. But what has happened is, initially, my lord, the assessment was made in 2015. In fact, my lord, this matter has in fact been considered by my lords in one of the rounds was before my lords, wherein my lord, the entire 79 lakh rupees addition was deleted. And I'll just give a brief background and take my lords through this order. My lord, what has happened is, what has happened is that
now twice 263 orders were passed, and on both occasions you were successful.
My lord, yes, sir. But what had happened in the entire proceedings, my lord, is that in the first round, the assessee had duly provided all the documents before the department. It is only because the directors did not respond to the 131 notice he made the addition. But subsequently, the assessee preferred an appeal, and that matter was carried to the tribunal. Thereafter, matter 263 was initiated, where he said that the entire
matter was pending before the tribunal.
Thereafter, first round of 263 happened, where he said that the entire order is set aside, assessment order is set aside. He directed a de novo hearing. Now, my lord, since that de novo hearing happened, the assessee in the course of those give effect proceedings provided all the documents, plus in response to 131 notice, my lord, as it is recorded in my lord's order also, the directors and even the investors appeared. And thereafter, my lord, the assessing officer gave a favorable order. Against that, my lord,
was in December 2016.
My lord, yes.
30th December 2016.
My lord. Thereafter, my lord, there was a second 263 that was done. The second 263 came before my lords. In that second 263, my lords, after recording everything, found that
when the second 263 was issued and he took up the matter, that was pending. No.
Yes, your lordship. If I may again explain, my lord, there are actually 4 rounds that have happened. In round 1, addition was made because directors did not appear to 131. That matter was pending before ITAT. Thereafter,
before Commissioner Appeals.
Commissioner Appeals. Then, my lord, 263 happened.
Yes. That assessment order was set aside.
Set aside. The 263 happened, my lord. We did not challenge the 263. My lord, what happened was in the give effect proceedings, I got relief from the assessing officer. He accepted my submission because even the directors and investors also appeared before him. Then, my lord, a second 263 happened. That tribunal gave me relief. They set it aside, saying that there is nothing.
No, you don't jump. Second 263 happened. You give your reply. In the meantime,
I did not. That was an ex parte order.
Ex parte order.
That was an ex parte order.
So 263 ex parte order. Soon thereafter, the department received, probably in the same month, information from the investigation department.
Yes, your lordship. 263
happened. Your dates and events.
Yes, your lordship. 263 happened. Then assessment proceedings started, and simultaneously they received allegedly some information from the investigation wing that there is some transaction with Sarika Trading. I don't even know who that person is. Thereafter, my lord, the matter of, as far as the 263 is concerned, that travelled up before this Honorable High Court. The second 263.
Wait. Once 263 direction was issued, the assessing officer started at de novo once again. And he also issued 148.
Yes, your lordship.
That was for a different reason.
My lord, actually, that is exactly one of the points taken by the tribunal. My lord, this entire 2 crore 47 lakhs, I have been denying the transaction, saying I don't know who the person is. What is your information? In remand also, he never discloses the information. And my lord, what happens is that before the tribunal, I was able to demonstrate that as far as my 79 crore share capital is concerned, that is accepted. The Sarika is not pertaining to that. Second is, my lord, my loans and other transactions are meager amounts, some 10, 15 or 1,000, and which has remained constant. So which is this transaction? So tribunal, besides on the 147 jurisdiction aspect, also gives me relief on this aspect, saying that what is this transaction? If my lord may kindly take the order of the tribunal, page 88, even this fact is very clear. So my lord, this entire 247 I can only deny because I don't know what it is. And this is in fact the fourth round, as I said, my lord, because normal 143 gave effect to 263, that where I was able to demonstrate everything. Then a third 263 assessment order, and now this 147 order, my lord. And in this, my lord,
and 147, the notice under 148 was issued when the second 263 was pending.
Yes, the second 263 gave effect was pending. My lord. My lord.
So then that 263 traveled up to the tribunal, you got relief. Appeal of the revenue is dismissed.
My lord.
Then 147 also traveled. He passed an order. You challenged it, and now you have got a favorable order
from the tribunal. And I can demonstrate, my lord, that in this entire proceedings in 147, but in fact in the facts also, but the department actually issued 147 proceedings. The assessee wasn't aware of the proceedings happening. When it came to know, when the show cause notice was issued in November 2019, when the show cause notice was issued, the assessee came to know about the 147 proceedings. They accordingly filed their return on 3rd of December. On 6th of December, my lord, they asked for reasons. And because the time was very limited for completing the proceedings, on the basis of the show cause notice and the extract of the reasons, my lord, which is also in the assessment order, they filed objections on 9th of December. The assessing officer it is actually a little difficult, is that he does not consider any of my replies of 6 December, 9 December. Now I take the matter to the Commission of Income Tax Appeals. Before Commission of Income Tax Appeals, my lord, in my submissions, written submissions and statement of facts, I categorically point out that on 6th and 9th of December, I filed objections and I filed responses. The assessing officer in the remand report doesn't touch on this fact. He simply says that the assessee has not been able to give any documents or details. He's not been able to produce that Sarika Trading, who I don't even know. He's not been able to produce him. No layering, nothing, no link to my account has also been provided. It is only on the basis of surmises. He doesn't deal with my objections of 6th or 9th of December. Even the Commissioner of Income Tax Appeals, he says the assessee has not been able to produce. Whereas, my lord, the rejoinder I have filed to the remand report, which he has annexed, which is reproduced in the order, I can demonstrate. He records that I have that annexure E and F of the submissions filed before him were the letters of 6 December and 9 December, which the AO does not, my lord, does not even counter in his remand report. And then, my lord, this matter has traveled. So he's not dealt with my objection.
Yet the CIT appeals dismissed your appeal.
They dismissed my appeal, saying that that initial onus is on me, whereas in 147, my lord, initial onus is on the department. They are supposed to show that what is the nexus. My lord, the reasons has been reproduced. Where they say Sarika Trading is basically an entry operator of Sandeep Roy. They have done transactions, layers are there, and assessee is a beneficiary. My lord, there are cases decided by this honorable court where even layering has been demonstrated, but without any independent examination, there is no 147 cannot be sustained. In my case, no layering has been provided. I have asked for details. Even in remand report and rejoinder, he does not provide me with any of the details.
See, this 79 crores 15 lakhs is a common figure in all the proceedings.
My lord.
In the earlier round, you have succeeded up to this court.
My lord.
This order has become final. Once again, how you...
No, my lord, it was found that, no, my lord, this is 2 crore, my lord. This issue was subsequently, my lord, that because, my lord, and it is not, my lord, 2 crore only, my lord, the huge cash was also deposited, 4.72 crores and 4.73 crores. That is, my lord, there in assessment order. Lordship will kindly see page number 11 and 12. Page number 11, my lord, Mr. Sarika Trading Company proprietorship concern has a current account number such and such of Sandeep Roy, proprietor. The firm said to be a grain supplier.
But then you didn't consider his reply. He has given 2 replies. You passed the reassessment order.
Yes.
But
Lord,
on 16th of December 2019.
My lord.
You did not consider his 6th December or 9th December reply. Just prior to that, on 6th December, the assessment order under 263 read with 144 was passed. And as against the reassessment, as against the assessment order under 263, they filed an appeal before the tribunal. They succeeded. You filed an appeal before the court, that was dismissed. Then as against the reassessment order, they carried it to an appeal. The tribunal says the...
but the appellate authority is finding, Lordship will kindly, Lordship will kindly says, page number 68 only, page number 68.
See, they say that there is no such transaction.
Yes.
The onus is on the department to show from some record there was a transaction.
Yes.
They produce their books and they say they have no
Yes.
transaction which has been routed through the books of the SSC with that Sandeep Roy, proprietor of Sarika Trading.
But what I'm humbly submitting on the basis of remand report, my lord, the remand report which was done by the DDIT investigation, my lord, there was a link of Mr. Sandeep Roy was there, my lord. From that remand report, my lord, this reopening was done. On the basis of that.
Investigation report. Remand report.
Investigation. Investigation.
But he was, in fact, having two parallel proceedings.
And that is
how he can do that in respect of the same facts. And tribunal has referred to some decision, SM Overseas Private Limited. Are you carrying that decision?
My lord, I'm carrying.
Where parallel proceedings cannot be done.
But actually, if I may be fair, my lord,
pardon?
1 point, but I'll be 100% fair, my lord. But the only way in which department can probably sustain that point, a line of argument, is that what if my 263 is set aside? If my 263 order is set aside, then these assessment proceedings become invalid, the give effect proceedings. So then my 147, if that is set aside on the ground that it's a parallel proceeding, and if my 263 order is also set aside, the commissioner's order, then my 147 goes away. So therefore, my lord, that is one argument that can be made to say that the 147 proceedings can be parallelly sustained if it's on a different information.
Correct.
This is my
yes, because they say it is based on, but then
but they've also decided on other points, my lord, that there is no information.
On merits also the tribunal has examined it.
On merits and also, my lord, on the fact that no information has been given despite me constantly asking the department for information and for nexus. I can demonstrate from the remand report also. Tribunal's order starts at page 85, para 9 onwards. We have heard the rival contention and peruse the material available on record. We have given a thoughtful consideration to submissions made by learned counsel for both the sides and issues as well as on merits of the case. From the chronology of events tabulated above, we note the fact that second revision order under section 263 dated 12/9/2019 has been quashed by the coordinate bench, making the second give effect proceeding order non-est. So this has been sustained by my lords. Reference made by the learned AO in the impugned assessment order of this proceeding and basing it to arrive at the aforesaid assessment total income is not justified. From the perusal of the reasons to believe recorded by the learned assessing officer and as contended by the learned counsel in respect of the contents mentioned therein, we are in agreement with the facts narrated by learned counsel that the learned assessing officer never disclosed the details of layers through which alleged money has been routed into the bank account of the assessee. Learned AO has never shared the information in respect of documentary evidence nor the alleged transactions of accommodation entry. We also do not find conduct of any examination of the alleged layering of the transaction to unearth the sequence of the flow of money alleged by the learned assessing officer escaping assessment. We have gone through the observations made by the learned AO in the impugned reassessment order, which shows that they are vague in nature. The same are extracted below for ease of reference. The reasons are given that Mrs. Sarika Trading, a proprietorship firm, has a current account with our Mission Row branch from 9/1/2012 onwards.
In this paragraph 9.1, the extracted portion, the assessee's name doesn't feature.
It doesn't.
But only in page 87, they say beneficiary Pearl Trade.
Yes, but actually, this is, if I can demonstrate from the assessment order, this is in fact a part of the departments. But nonetheless, they have identified me as a beneficiary only. They've come. But where is the layering? it is only on the basis of the investigation officer's report. But where is the layering, my lord? There is a decision, my lord, of Prashant Desai, wherein my layering was done. Even in that case, in the absence of any corroborating material, it was held that 147 proceedings are unhonest.
In fact, normally they put a chart, flow chart.
Yes.
Layer 1, layer 2, layer 3, and layer 4.
That is not there.
This is one of those cases wherein relief has been granted also. At paragraph 4 onwards.
That you should have established that. But here also it is very vague. If you come to page 87, the extracted portion, third paragraph.
Page 87.
87. That in italics, third paragraph. On examination of the bank statement mentioned above, observed cash is deposited in the account simultaneously, followed by debits to various accounts. These accounts have been frequently used for layering of funds through several bank accounts. This is all very vague, general statement.
This has been recorded also. Even the nature of transaction is not mentioned, and that is relevant because, my lord, my 79 crores is explained. Besides
that is accepted by the AO at the first instance.
First instance, then, my lord, that is accepted. Secondly, my lord, now as with respect to this 2.47, and even the directors of those companies have appeared, as recorded by my lord's order also. Those companies' directors have also appeared, the investors. This 2.47, my lord, if my lord may kindly take para 9.5 at page 88.
Now, this order is under 495, ITA 495 of 2022. This was an appeal filed against
the second 263. The second 263.
That is 6th December.
My lord. Yes. No, not 6th December. This is my lord.
Second.
Where is it? What? Just notice.
You see your dates and events, third page.
6, yes.
My lord, my lord.
6th December. Yes.
My lord.
So this is against the 6th December order, and that was their appeal against that was dismissed. So that has to go. Assuming he had some fresh information, then whether it was proper to justify reopening. That's the only issue. How many times the assessee is being put? Please come. This appeal has been filed by the department, by the revenue, under section 260 cap A of the Income Tax Act 1961 within bracket the Act, challenging the order dated November 10, 2023, passed by the Income Tax Appellate Tribunal, B-Bench, Calcutta within bracket Tribunal, in ITA number 375/2023 for the assessment year 2012-13. The revenue has raised the following substantial questions of law for consideration. A, B, C, D not required. We have heard so and so. The assessee preferred appeal before the learned tribunal against the order passed by the Commissioner of Income Tax Appeals within bracket, Calcutta 21 within bracket CITA dated 23/2023, by which the CITA affirmed the reassessment order dated 16/12/2019 passed under section 147 read with section 143 within bracket 3 of the Act. A small prelude is required before we embark upon the exercise of examining the correctness of the decision of the learned tribunal impugned in this appeal. The assessee filed its return of income for the assessment year under consideration within bracket AY 2012-13 on 6th February 2012, declaring a loss of rupees 74,252. The case was selected for scrutiny and an assessment order was passed under section 143 within bracket 3 of the Act on 20th March 2015, wherein the entire share capital raised by the assessee was added and the total income was assessed at rupees 79,14,03,750. To be noted that the assessing officer does not dispute the fact that the assessee provided the relevant documents and explained the transaction apart from the identity and the creditworthiness of the share applicants and the genuineness of the transaction. However, it appears that the additions were made on account of non-compliance of the requirement under section 131 of the Act. While so, the Commissioner initiated proceedings under section 263 of the Act by passing an order dated 17th October 2016, directing the assessing officer to conduct de novo assessment, pursuant to which notice under section 142 within bracket 1 was issued on November 11/11/2016, and the assessee responded to the notice to provide details and documents, and the directors of the assessee as well as the share subscribers appeared in response to the summons issued under section 131 of the Act. The assessing officer was satisfied with the documents and details provided as well as the statements recorded from the directors of the assessee and the share subscribers, and he completed the assessment by order dated 30/12/2016 and assessed the total income at rupees 1,17,342. Once again, the Commissioner initiated proceedings under section 263 of the Act, being the second round of revision proceedings, and an order was passed on 12th March 2019, setting aside the assessment order dated 30/12/2016. It is seen that the said order passed under section 263 dated 12th March 2019 was an ex parte order. The assessee preferred an appeal before the learned tribunal in ITA number 495/KOL/2022. During the pendency of the said appeal, the assessing officer issued notice under section 148 of the Act based on certain information stated to have been received, alleged to have been received from the DDIT within bracket investigation, unit 4 within bracket 2 Calcutta, through their letter dated 27/2/2019, that the assessee had taken accommodation entry of rupees 2,48,50,000 from Sandeep Roy, proprietor of Sarika Trading Company. Notices were issued under section 142 within bracket 1 of the Act, and on 15/11/2019, show cause notice was issued by the assessing officer in the course of reassessment proceedings. The assessee on 30/11 for assessee filed its return on 1/12/2019 and also filed the copies of the audited financials and the bank statement during the course of the reassessment proceedings, and also requested for the reasons for reopening, and specifically denied that they have not entered into any transaction with Sandeep Roy or his firm. This could be seen from the communications dated November 30, 2019. Sorry, instead of that, 3/11/2019, 3/12/2019, and 6/12/2019. No reasons were not furnished, but taking a cue from what was extracted in the show cause notice, the assessee filed its objection on 9/12/2019 to the show cause notice and the notice issued under section 142 within bracket Act 1 of the Act, and denied and specifically denied the alleged transaction with Sandeep Roy or his firm, Messrs. Sarika Trading, and submitted that such allegation was not supported by any document or evidence. While so, an assessment order was passed under section 263, read with section 144 of the Act on 6/12/2019, adding the entire share capital again as income of and the income was assessed at rupees 79, 15, 95, 340. After about 10 days, by order dated 16/12/2019, reassessment order was passed under section 143 within bracket 3, read with section 147 of the Act, reckoning the income to be rupees 79, 15, 95, 340, and making an addition of rupees 2, 48, 50, 000. As is evident from the above proceedings, the objections which were filed by the assessee on 9th December 2019, 9/12/2019, was not disposed of. The assessee preferred an appeal before the Commission of Income Tax, before the CITA, and a rejoinder was also filed by the CITA, who had called for a remand report, and the assessee also filed a rejoinder to the remand report filed by the assessing officer. Remand report, rejoinder to the remand report by the rejoinder dated 28/2/2023. The learned tribunal allowed the assessee's appeal in ITA number 496/KOL/2022 by order dated 6/3/2023. The appeal which was preferred by the assessee as against the reassessment order was dismissed by the CITA by order dated 20th March 2023. This order was put to challenge before the learned tribunal in ITA number 375/KOL/2023, which was allowed by the learned tribunal by order dated 10/11/2023, which is impugned in this appeal. As against the order passed by the learned tribunal in ITA 495/KOL/2022, dated 6th March 2023, the revenue preferred appeal before this court in ITAT 267 of 2023, which was dismissed by judgment dated 8th January 2024. The relevant paragraph, the relevant portion of the judgment is quoted here and below. Sir, page 2, no paragraph numbers, sentence starting the short question till the end. The above dates and events will clearly show that the assessee has been exposed to multiple proceedings for the very same assessment year. Be that as it may, when we carefully go through the materials placed on record, as well as the reasoning given by the learned tribunal, we find that the decision taken by the learned tribunal was fully justified in the facts and circumstances of the case. Full stop. We support this conclusion with the following reasons. As noted above, the order passed in the second revision. No, order passed pursuant to the second revisional order passed under 263 has been quashed by the tribunal, which has been upheld by this court. The reasons to believe for reopening the assessment has been recorded by the assessing officer, and on going through, we find that the name of the assessee does not feature in the body of the reasons, but the assessee has been shown as a beneficiary. With in the paragraph, no, in the reasons for reopening, in the paragraph titled inverted comma details of inquiries made inverted comma close, there is no specific allegation as to against the assessee and as to how the layering of funds have taken place. This aspect of the matter was considered by the learned tribunal and found that the assessing officer never disclosed the details of layers through which the alleged money has been routed into the bank account of the assessee, nor any information was shared in respect of any documentary evidence for the alleged transaction of accommodation entry in which the assessee was stated to be a beneficiary. This finding of the London Tribunal is well justified. Apart from that, we also find that no specific reasons have been mentioned by the assessing officer as to the nature of the transaction of accommodation entry qua the assessee, and this aspect was examined by the tribunal, and it was observed that the assessing officer does not disclose as to whether it is an income or an expense or an allowance or share capital or loan, etc. It is not in dispute that the assessee has produced the books of accounts and the bank statement to demonstrate that there was no transaction with the alleged accommodation entry provider, Mr. Sandeep Roy, proprietor of Messrs. Sarika Trading Company. The factual aspect of the matter as regards the share capital and share premium was examined by the assessing officer in detail and was accepted and the stand taken and the documents and details furnished by the assessee was accepted while passing the assessment order dated 30th December 2016. The attempt to reopen the said revise the said order by way of a second revisional order under section 263 proved futile, as the assessee was successful before the tribunal as well as before this court. Thus, the learned tribunal, on considering the factual position, had rightly granted relief to the assessee. At this juncture, it would be of relevance to take note of the decision of this court in the case of Principal Commission of Income Tax 80, Kolkata versus Prashant Desai, 2025 6 TMI 984-Calcutta High Court. Wherein also there was an allegation of layering. In fact, the facts of the case on hand is much stronger for the assessee than the case in the case than that of the case of the assessee Prashant Desai in the above decision. The court took note of the factual position and also the decision of the Honorable Supreme Court in Income Tax Officer versus Lakmani Mewal Das, reported in 1976 103 ITR 437 within bracket SC, wherein the Honorable Supreme Court held that the reasons for formation of the belief must have a rational connection with or relevant bearing on the formation of belief. Full stop. Rational connection postulates that there must be a direct nexus or live link between the material coming to the notice of the income tax officer and the formation of his belief that there has been escapement of the income of the assessee from assessment in the particular year because of his failure to disclose fully and truly all material facts. Thus, the tribunal after examining the factual position, had rightly granted relief to the assessee by passing the impugned order. For the above reasons, we find no question of law, much less substantial question of for consideration in this appeal. Accordingly, the appeal fails and is dismissed.
Great.
There is a delay, is it? No.
Delay was earlier court.
I'm grateful, Your Lordship.
Item number 14.
Your Lordship, I'm praying for a not today in this matter, Your Lordship.
Not today.
When the last occasion they asked for a specific, there is a specific wrong in the order of the IT-80. They prayed for time.
On the same ground, Your Lordship, I'm being led by my learned senior in this matter, Your Lordship. If Your Lordship would be kind enough to just grant me a not today.
Item number 15.
Grateful, Your Lordship.
Section 68, Madam Lord, if Your Lordship will. But if Your Lordship will kindly see, my Lord, the assessment or short assessment order. But page number 11, my Lord. During the course of assessment, was observed the director of the share allotment company or the share allotee companies are the same. My Lord, this is the question. My Lord, first the questions are not at page number 5, my Lord. The questions are not. My Lord, 68 not deleting genuineness and creditworthiness of the. My Lord, during the course of assessment was observed that the share allotment companies, the share allotee companies are the same. Mrs. Rajkumar Damani, the statement of Rajkumar Damani has been recorded in 131 of the Act. The statement of Rajkumar Damani, Director of Majestic Vyapar, that is a appellant here, but recorded during the proceedings under section 131 of the Act, and in the chamber of such and such, my Lord, that he says that I swear that, my Lord, certain statements were recorded, my Lord. My Lord, in the question 9, my Lord, if Your Lordship will kindly see question number 9. Yes. Page number 13. Mr. Rajkumar Dani, you are the director of all these companies of Mrs. Majestic Vyapar Private Limited, of Janus Tie-Up and Mrs. Kipi Engineering Limited. And why it shall not be considered that you transfer your own surplus funds from one fund to the another companies? Yes, I already answered in question number 8 that there is a surplus fund in my other companies, and I am the only utilizing the same for expanding the business. So it cannot be treated as a transfer
What
of
more do you want? The directors have been examined. They produce all the books of account, etc., etc. PAN, audited account, bank statement, confirmation letter. The share subscribers also were examined. They have given statement.
Yes.
Yet you doubt the transaction. What more do you want? And rightly, Balgopal Merchant, they have distinguished. There, in fact, in that case, they allotted to 2 group companies at the face value of 10 each, and at a premium of some 4,900. Please come. This appeal filed by
I'm led by Mr. Vipul Kandole in this matter.
This appeal filed by the Revenue under Section 260 capital A of the Income Tax Act 1961 is directed against order dated August 22, 2024, passed by the Income Tax Appellate Tribunal, SMC Bench, Calcutta, within bracket Tribunal, in ITA number 902/KOL/2024 for the assessment year 2014-15. The Revenue has raised the following substantial questions of law for consideration: A and B, C, D, E, and F are not required. You have heard so Tilak Mitra, etc., etc. The learned tribunal had allowed the assessee's appeal and set aside the addition made under Section 68 of the Act. We have perused the order passed by the assessing officer dated 23/12/2016 under Section 143 of the Act, and the order passed by the CITA dated 28/2/2024. The CITA has affirmed the order passed by the assessing officer but has not given any independent reasons. The question which falls for consideration is whether the power under Section 68 of the Act could have been invoked in the facts and circumstances of the assessee's case for the assessment year under consideration. The tribunal has taken note of the factual position that the assessee has issued equity shares to 2 group companies, and the 2 group companies have common directors. According to the assessing officer, those companies were not having sufficient business activities and were having only loan transactions and non-current investments. Non-current hyphenated word. It is not in dispute that the assessee filed all the evidence and submitted explanation as called for by the assessing officer, namely by furnishing the names, addresses, PAN card numbers, audited accounts, bank statements, confirmation letters, etc., to establish the genuineness of the transaction apart from identity and creditworthiness. The directors of the assessee as well as the share subscribers responded to the summons issued under Section 133 within bracket 6. And the director has given a statement that the subscribing companies have substantial resources available to invest in the assessee company. And the same work and the said statement was also substantiated by other records. The assessing officer has not brought on record anything to dispute or doubt the stand taken by the assessee as well as the share subscribers, nor commented upon the veracity of the documents and details furnished by the assessee during the course of the assessment proceedings. In such circumstances, the tribunal granted relief to the assessee. We find the matter to be entirely factual, which has been reappreciated by the tribunal, and relief has been granted to the assessee. Thus, we find no question of law, much less substantial question of law arising from.
I'm grateful.
Matter number 16.
Lord, 16 to 22, Lord, this is a Marlin Group's matter, Lord. What happened, Lord, Marlin Groups also filed 24 writ petition before the learned single judge. This is the challenging the assessment order, and before the learned single judge challenging the penalty order. Now, yes, now the department has engaged learned ASG in the single judge court, in writ petition matter. Therefore, our endeavor also is that the learned ASG also appeared in this appeal also. But I am praying 2 weeks time for that reason.
If I may indicate couple of things, my lord, this matter was earlier heard by my lords. In this appeal, my lord, in this matter being led by Honorable Mr. S.M. Mukherjee, in this matter, what had happened was that the department is acting not on the basis of incriminating material found during search, but on post-search investigation. So the question before my lords in this case is that whether they can rely on any post-search inquiry for the purpose of 153A proceedings and 153 proceedings.
After the official bill, the scope of the appeal may be limited. Because all assessment are completed assessment. There are cases that there is no incriminating material, no name is appearing in the document. And it cannot be shown as incriminating material in view of the official bill. But there is another. I am led by Mr. But there is another angle of the matter. But nobody looked into, even the ITAT also not look into official bill given one liberty to the assessing officer regarding reopening. Even if the case relates that there is no incriminating material, but power is given to the assessing officer for reopening, the tribunal did not look that. It says only that there is no incriminating material. Occasion when arise, will submit. It is not the simplicity that there is no incriminating material. Even if not, may I submit even in this way, if the name of the assessee is not in the document, but facts and circumstances says, if we can establish that is incriminating materials, we will place that.
Now, the writ petition has been filed challenging.
But actually, that, my lord, is a completely separate proceeding. If I may indicate, my lord, 148
yes,
is not here.
We are admitting assessment and penalty procedure. We are not saying,
but why
did you file a writ petition?
But actually, what has happened is, this is not the penalty proceedings arising from the assessment. In the 153A orders, not even 148. So, my lord, there is no overlook by the tribunal. In 153A orders, my lord, they have basically given directions for 271(1)(c). But after 3 years from the conclusion of the assessment proceedings, now they're initiating proceedings under 271D, D, E, and E without any satisfaction being in the assessment order, my lord. And my lord, it is a decision of the Honorable Supreme Court.
The order passed.
Therefore, my lord, since the
penalty order also the appellable order. Penalty order is appellable order. They have approached the court.
If we granted
what they say is, while completing the assessment, the assessing officer has said 271(1)(c) penalty proceedings will be initiated.
My lord.
But there was nothing recorded that in respect of other subclasses they will do it.
Absolutely, and that too 3 years later, we've been given an interim order in the matter as well. My lord. The writ petition's been admitted, and interim orders have been.
That has got no bearing on this. Let it go on.
No, not bearing. But we have seen. it prejudice the mind of the judges when the assessment order goes.
This is not 148A proceedings.
We are now simplicity playing 2 weeks time. If your lordship, let us come back.
Should we record that you want to engage as
Not required, my lord. You lordship kindly.
15th, my lord.
This month.
My lord. He's praying for 2 weeks, my lord.
Okay.
15th. This matter was heard by my lord.
22nd.
Fine.
20th to 25th, I will not be there, my
lord. But it will not take too much time. 15th.
17th.
Yes. 28th to 25th.
17th.
17th.
18th.
All right, 18th.
18th, man. I'm grateful.
At the request of the learned advocate appearing for the appellant department, 18th. Up to 22.
I'm grateful, your lordship.
I did not 23.
23 and 24. Matter was heard by your lordship. Mr. Mitra was arguing. Tilak Mitra. He has some difficulty today, my lord.
We'll say not today.
Not today only, yes, ma'am.
22 and 23.
Yes, not
24.
24, my lord, separate matter.
That is also same as SC.
22.
Oh, sorry, 23 and 20.
Yes.
I done 25.
25, your lordship will take
some other day.
Not
all right. We'll stop with this.
25, I appear for the response.
Let it remain in the list. Tomorrow we'll continue. That order passed. So that we can upload it by 3 o'clock.
Number 1 to 4.
Lordship, by your Lordship's order dated 25th May, your Lordship had passed certain directions.
May I? The directions number 1 was with regard to that honorarium to be increased from 1,000 to 5,000. My lord, this is under active consideration by the Social Welfare Department. My lord, your Lordship directed me to file the department concerned to file a report in the form of an affidavit. So, my lord, they wanted some time to file a report in the form. With regard to that,
your principal secretary, madam, is a very active person.
Shanghamitra
Ghosh.
Right.
We are confident that she will definitely.
Well, I have spoken to her, my lord. She will, my lord. So this is
nowadays what to
well,
do.
it will be 1,000 is nothing. My lord, the second direction was with regard to that 5 wheelchairs to be provided.
Yes.
5 wheelchairs to be provided, my lord. It has been provided there in the hospital.
Let us go one by one.
Lordship.
Paragraph 8, the court would suggest the stipend of rupees 5,000 per person, so and so.
Paragraph 9, your Lordship.
9 direction.
Right. So we'll be seeing a week's time, my lord. We'll come with a report.
No problem. That is for then wheelchairs have been provided.
Provided, my lord.
Wheelchairs in the hospital.
It has been provided.
Our ultimate requirement will be if wheelchairs could be provided to the. But at the moment, we shall be happy with that.
Yes. Next aspect is
this is the report with regard to the wheelchair.
3-bed ICU unit.
My lord, this 3-bed ICU, my lord, this matter has been taken up. I have the photographs of the wheelchairs also. 5 wheelchairs.
No, we take your words.
I'm good. Right. My lord, with regard to 3-bed ICUs, my lord, this matter has been taken up with the higher authority, my lord. My lord, this is the file noting. I am not able to share that file because this is the departmental file. If your Lordship kindly comes to the page numbers are given at the bottom. Page 7. Page 7. My lord, after serial number 2 in my lord.
Yes.
Actions taken so far by the Center of Excellence, COE. Serial number 2. My lord, if your Lordship kindly comes to that italics A, a 50-bedded critical care block is on its verge of completion at KPH, that is Kolkata Police Hospital. Has your Lordship got that? 3 ICU beds can be demarcated at this CCB for rare disease patients when it starts functioning, or a space for setting up a 3-bedded ICU unit can be provided at the ground floor at KPH. Then additional requirement of necessary infrastructural setup, equipment as per requirement of ICU and additional manpower will have to be provided from the state.
I think proposal B is better.
Ground floor is always.
It will be separate.
Separate.
It will be separate.
And this should be earmarked for muscular dystrophy. Rare disease is a very big area.
It has been taken care of, my lord. If your Lordship kindly comes to page 11 of that file noting. This is of 14 June to the. My lord, if your Lordship kindly sees that highlighted portion. Hence, it may be proposed that in line with the suggestion of the Honorable Court, it may be placed before the Honorable Court that the state government is actively considering these available options for establishing the 3-bedded ICU unit in the KPH exclusively for the person suffering from rare disease, apart from the facilities available in the SSK model or other hospitals. So it is being, my lord.
I think that's a good move.
That's a very good move, but Lordship, I was saying that it be earmarked for muscular dystrophy. Rare disease is a very large area. So this has happened in the case of muscular dystrophy patients that since they have a limited lifespan.
What are the other types of rare disease?
There are different types of rare disease. So, my lord, if 3 is earmarked for muscular dystrophy, then for other rare diseases, my lord, then we have to go for some 15-20 bed ICUs.
That also may be necessary in the long run. The rare disease.
What they say is there is a 50-bedded critical care block in the verge of completion at the KPH.
Kolkata Police Hospital.
3 can be earmarked. Instead of 3 you earmark for muscular dystrophy, 2 more for other rare
disease. That will be. That would be good.
3 plus 2. Right. in the ground floor.
Coming back to your Lordship's order of 23rd May 2025. But this is with regard to tablet Deflazacort at paragraphs 23 and 24.
Lordship, I'm told that this has started, but what my clients were asking is along with Deflazacort, they should also mention, Lordship, they need PAN 40 and a vitamin tablet. Lordship, that also should be included so that they get it together.
That can be prescribed by the doctor only. Because
no, that is necessary. That is necessary for all.
My lord, these are all. My lord.
This is a very small medicine. I mean, PAN 40 is so common. I'm just saying that so they don't have to come repeatedly, just to lessen. In fact, I'm told by my client that it is.
So now for 2 months.
For 2 months, it has started. That has started for one.
And apart from that, you want pantoprazole and vitamins.
A vitamin and PAN 40. Calcium. These are the also medicines which are given. If it is recorded in the order,
but
then
it's not PAN D better than PAN 40.
Whatever.
But it is.
Steroids, no, they have a.
We can't.
It doesn't take the digestion tablets. They will develop acidity.
Acidity.
Steroids have also many side effects. Like my own son is suffering from this eye cataracts because of steroids, because he has been taking for 5 years, and also is suffering from osteoporosis because of this. These are the side effects of.
But in our order, we cannot name the drug. We can say that to treat the symptoms or.
Lordship, I was merely suggesting the necessary medicines, if it could be included, if the 2-month period is given for also
For
these.
that, my lord, because the last occasion I had the, my lord, the particular lady, the lady doctor, my lord, the head of the department, she was there. She was there. So she could take the call whether these medicines are required or not, because PAN D and PAN 40, my lord, they have different functions. I am addicted to PAN 40. So PAN 40 is with only with whoever is suffering from gastric problem, and PAN D is gastric along with this vomiting problem. For those, my lord, PAN Ds are recommended as far as I know with regard to these medications. So I think, my lord,
first we will record this and then come back. Reference may be made to the order dated 23/5/2025, which several issues which were pointed out were highlighted, and certain directions have been issued. The first of such direction was to consider providing a stipend of rupees 5,000 per person suffering from rare diseases, and the appropriate authority of the state government was granted liberty to respond to this suggestion by the court by filing a report in the form of an affidavit. The learned senior advocate appearing for the state on instruction submitted that the issue is being deliberated at the highest level and seeks for reasonable time to file a report in the form of an affidavit. The such submission is placed on record, and let such report in the form of an affidavit be filed on the next hearing. The next direction was to provide 5 mechanized wheelchairs in the hospital. This direction has been complied with, and in proof thereof, the report of installation as prepared by the General Manager, West Bengal Medical Services Corporation Limited, dated 10/6/2025, has been placed. The same is taken on record, and the said issue stands addressed. The third aspect is with regard to providing the tablet Deflazacort, DEFLAZECORT, for a minimum period of 2 months. To the said effect, an order has been passed by the medical superintendent cum vice principal, IPGME&R -SSKM Hospitals, Center of Excellence, dated 27th May 2025. The learned advocate appearing for the petitioner would submit that along with the aforementioned drug, there are other drugs which are required to be taken by the person suffering from muscular dystrophy, as they often suffer from other symptoms on account of being administered with steroids. the medical specialist shall consider this aspect as well. And in addition to the tablet deflazacort, such the medicines which are required to handle the symptoms as well as for improving the health of the patients may also be provided for a minimum period of 2 months. The next aspect is providing exclusive ICU unit for the person suffering from rare disease. It is submitted by the learned advocate appearing for the petitioner that rare disease within inverted comma is a very broad classification, and exclusively beds, ICU beds may be reserved for persons suffering from muscular dystrophy. 2 proposals have been given, of which we find the proposal of setting up a 3-bedded ICU unit in the ground floor at KPH to be more effective to address the need, since there are various categories which fall under the broad classification of rare diseases. We would recommend a 5-bedded ICU unit to be provided at the ground floor at KPH, of which 3 beds can be reserved for persons suffering from muscular dystrophy, and the remaining 2 ICU beds for the persons suffering from other rare disease. The appropriate authority is directed to consider this suggestion, and it will be well appreciated if the same is accepted. Then next, what happens next?
What are the direction upon the central government to see, my lord, whether another center of excellence can be set up in the state of
so for in respect of that,
স্টেটের ওড়িশা যার সকলে এই স্টেটে দেখা যায় একটা সেন্টার অফ এক্সেলেন্স আছে
North Bengal
Para 29.
I will receive the instructions. Kindly takes up paragraph Roman 3 at page 2 of bottom. Lordship, the records, there has been 770 rare disease patients who has been registered with the COE Kolkata, Lordship. And if the Lordship can kindly takes up paragraph Roman 4, Lordship, it has been submitted that so far in respect of the states concerning Jharkhand, Odisha, Assam and Bihar, these proposed COEs are already in the pipeline, Lordship.
So if that is established, those patients will not travel here.
Those patients will not definitely come to West Bengal for the treatments. So far in respect of the rare disease as concerned, Lordship. And since there has been only, as of now, there has been only 13 center of excellences in the pan-India, Lordship. So considering that perspective.
But if only the patient load is only 770, one more center of excellence will be difficult.
That's true.
And if the other 4 states get the COE,
then there will be less pressure on.
And there can be more attention to
vis-a-vis with Lordship, if you can Lordship kindly appreciate on the fact that since there's only 13 COEs as of now presently in the whole of the country, so having an additional COE in a state will be slightly.
When some of the states don't have a center of excellence.
Lordship.
Lordship, there is.
First, what we'll do is we'll get the report regarding stipend, and let them come back on the proposal of 5 beds, 3 for muscular dystrophy, 2 for the
other rare disease.
Then with regard to this, we will place this on record, the report of the Government of India, and then we will see.
Your Lordship, there has been another suggestion from my clients.
Well, we'll finish this. The other, with regard to No. By an earlier order dated 17/4/2023, the learned Additional Solicitor General was requested to provide necessary information whether other centers of excellence, in addition to the present located in Kolkata, can be established in other parts of the state of West Bengal. In this regard, a response has been given by the Under Secretary to Government of India, Ministry of Health and Family Welfare, Department of Health and Family Welfare within bracket Rare Disease Cell, dated 17/6/2025, addressed to the learned Additional Solicitor General. From the said communication, it is seen that as per the data furnished by IPGMER, 770 rare disease patients have been registered at the institute over the last 5 years. And given this patient load, it is not considered feasible to designate more than one center of excellence in the state of West Bengal at this stage. Furthermore, the communication states that the request for consideration of center of excellence in the states of Jharkhand, Odisha, Assam and Bihar is under evaluation. For their potential evaluation, for their potential recognition as centers of excellence in accordance with the standard criteria. Therefore, for the present, it may not be feasible for considering the request for opening one more center of excellence in the state of West Bengal, more particularly when there are only 13 centers of excellence in the country and some of the states do not have the said facility. The communication sent by the Government of India, addressed to the learned Additional Solicitor General, dated 17/6/2025, is taken on record, and the matter stands closed at that. Stands closed. And the issue stands closed. Then one more thing we said for the wheelchairs for the people.
Lordship, regarding wheelchairs, I've just been told there is a company called Karma which provides 10,000 rupees wheelchairs. These are light, portable, meant for younger people. The ones that are given now are heavy, some of them mechanized, but this is a much cheaper vehicle.
Where is the manufacturing unit?
Karma is...
we have a Karma Health Care. There is a company.
In West Bengal?
Not in West Bengal. In India, some place we always buy those wheelchairs through Amazon.
Please Google and find out.
Bangalore.
You are holding an iPhone. Google and find out Karma.
One of this type of wheelchair, state government wants to, there should be a tender. Then it will go to the committee. But
no, last time we have said no tender business.
Lot of things go on without tender.
Then we will compel you to sponsor one wheelchair. Mr. Tapan Kumar Mukherjee will sponsor.
I'm told it's in Salt Lake only, Vidhannagar.
I can see one Karma Healthcare Limited, Vidhannagar, North 24.
Karma Medical.
So that's very new. That's within Calcutta.
Karma Medical. Next generation of lightweight mobility.
Karma Healthcare.
Where is the registered office or manufacturing unit?
Internet.
But unfortunate, the Chamber of Commerce, nobody has responded.
Yes, that. But I will be at it again. Lordship, I cannot give this.
Mr. Pratyush met me today. For some other reason, I forgot about it. As a result, all the invitations they sent.
You have not, Lordship has not accepted on this ground.
China company.
It is possibly a Chinese company, Taiwanese company.
They have some branches in Kolkata, like Karma Healthcare. It's
in Salt Lake. Salt Lake.
We will not record anything. If you can obtain a pro forma invoice.
Lordship.
I do have a person from Karma who actually my son's wheelchairs sometimes got.
You come forward, no?
My son's wheelchair wheels got destroyed like I called that man from Karma. He came and
Repaired it.
repaired. So I know that man.
So you ask him
Ah.
that the court is considering your request.
Hmm.
What is the minimum price
Hmm.
of a foldable wheelchair?
10,000 is a minimum.
No, the pro forma, ask him to give in
Acha.
your name.
Okay.
In
okay.
your name, you take a pro forma invoice.
Okay. Okay.
You bring that. We will ask them to sanction.
Okay.
How many people are you? How many wheelchairs would you require?
How
Okay,
many
sir.
wheelchairs? Oh,
The patients we have, like
at the
No,
moment,
madam.
how many wheelchairs?
770 is the patient load,
Mhm.
which includes all rare diseases. So far as muscular dystrophy for children,
Uh-huh.
there will be 150, 70,
Abhi,
25.
I have a list. Now I have 20 people in the list who wants these wheelchairs. So this is a manual wheelchair.
A manual wheelchair. Somebody will be able.
Yes, but it's lightweight and it's cheap.
Lightweight, durable and cheap, and it's okay. Like instead of that big 5,000 rupees wheelchairs, which are adult wheelchairs, these wheelchairs are very good for the parents also to push.
Lordship, in this regard, I was told that wheelchairs is one of the considerations, but the other considerations are things like knee orthosis, braces, belt for spine. Lordship, this is supplied by the National Institute for Locomotor Disability in Bonhugli. They are supposed to supply this free of cost, and these are very necessary for some of these. Some of the patients may not have come to the stage of wheelchair. These braces or these
to support them.
And to some of their legs get so
No, you are saying this National Institute of?
For locomotor disability.
This is a central government organization.
It's a central government organization in Bonhugli.
In
Bonhugli. B-O-N.
Near Calcutta. On opposite to ISI. Opposite to ISI.
Oh, opposite ISA. ISA we know because matter was here.
So therefore, if an order is passed by
On way to BT Road.
Yes.
You can find out.
Lordship.
Certainly. ASG is here in Kolkata today.
Lordship, he's unwell.
But he is here in Kolkata. We will record as if he.
Lordship, I was just praying if an order is passed, they do not give us attention. But if an order of this honorable court is passed, then they will give it free of cost.
So we will get it from in the aforementioned in the earlier order, a suggestion was made to the state government to consider whether a subsidy can be given for the purchase of mechanized wheelchair. And the cost and the initial cost will be borne by the parents of the persons suffering from muscular dystrophy, rare disease / rare disease within bracket, in particular muscular dystrophy. It is submitted by the learned advocate appearing for the petitioner that there is a company which supplies lightweight, foldable wheelchairs at very affordable price. We direct the parent of one of the child suffering from muscular dystrophy to obtain a pro forma invoice from the said company to assess the financial outlay that may be required to be provided by the state government for purchasing this type of such wheelchairs. Let such pro forma invoice be placed before this court on the next hearing date. The next aspect which has been highlighted before us is that persons suffering from muscular dystrophy may require other devices, such as, what is it called, madam? Brace?
Lordship, knee orthosis, braces.
Knee orthosis.
Lordship, may I just hand over this? My client has actually written down the things. AFO is another of these.
If you say like may require AFO night splint legs, knee orthosis, braces / belts for spine. And we are informed that these items are supplied free of cost by the National Institute for Locomotor Disability, which is located at HON'BLE. We request the learned Additional Solicitor General to obtain appropriate written instructions from the director of the said National Institute as to whether these items could be supplied to the person suffering from muscular dystrophy upon due certification by the concerned hospital free of cost. It is brought to the notice of this court that these items are required for persons who are in the early stage of muscular dystrophy and who are not wheelchair bound. Let the director of the National Institute of Locomotor Disability gives appropriate written instruction to the learned Additional Solicitor General in this regard.
Amazon around 10,000.
BiPAP machine also they are supplying, is it?
Lordship, they are not supplying BiPAP machine. In this connection, I would say that a sleep test is very necessary for these children, because what happens during the daytime, they can give out the carbon dioxide, but during nighttime, while they're sleeping, the carbon dioxide limit remains, it doesn't go out of the body. And for that...
BiPAP, there are various categories.
Yes.
But some of them which are very effective are very expensive.
I know, Lordship. I have bought one. It's very expensive. It is not possible. But I was saying that the sleep test...
It is not a one-time investment. There is a recurring expenditure.
That's true. Lordship, but before that, the sleep test...
People carry that along with them when they travel.
Yes, nowadays they are traveling all sorts.
We have a card that has been inserted, just like a phone card, or we have memory card. As a memory card, we have to put inside the machine and it will be recorded. If when we go to the lung doctor, we carry that card.
But that sleep study test can be done
at the COE, Lordship.
In the hospital.
Yes.
It's a whole night process. Now, one child has to be kept asleep for 6 hours, and then his lungs in and out capacity of carbon dioxide and oxygen.
But in that hospital, that bone density test that is available.
It's done. DEXA scan is being done. That is being done.
So we were, this was my humble suggestion, that if the COE could carry out on the registered patients who have disability cards, the sleep test.
In that we said 5-bed ICU, etc. In that one paragraph you also had. It is submitted that the persons suffering from muscular dystrophy have to be assessed for their sleep pattern, and therefore a sleep study test is required, which can be conducted by using appropriate equipment. The concerned authority of the state government shall also respond as to whether such sleep test study, such equipment for the purpose of conducting sleep study test can be installed in the KPH along with BiPAP machine. This aspect shall also be addressed in the report, which shall be filed by the address in a report to be filed by the appropriate authority of the state. You put this as one separate paragraph. If you want, you can have this. And what about that disability card?
It is being issued, but what I have been told by my client is that there is no uniform procedure in all hospitals. So people are facing certain difficulties. My learned senior friend was also just
Lordship, this gentleman who works in the High Court, Lordship, his experience is that he had registered in 2020. The card was given this year. At that point of time, his son had 70% disability, which has now come up till 95. But they are not recording that. They have said that you applied in 2020, it was then 70%. This is what we are going to record. These are small things, but makes a lot of difference.
Because unless we get 90%, we cannot avail air travel.
And who certified it is 90%?
Lordship, the hospital, when they were having the treatment.
And then that portal should contain an option to upload.
The state government has already closed down its portal. Now they have to
central
central government portal now.
But what they say is, no. Who issues on the date of application, the patient was 70%, assessed 70%. Certificate issued after 5 years.
Obviously, it has gone up, and he says there's a disability board in each of hospitals, and they give that.
Who has to give this data on that certificate? Which authority?
The disability board of the particular hospital.
In Calcutta, not central government.
No.
They give
In
the
Calcutta.
certification.
Correct, sir.
Subject to correction.
Now he has got a certification that his son is 90%.
90%. Then he will file.
That has to be, uploaded
in the portal.
Yes.
Lordship, the mechanism which happens.
Use the mic so that everyone.
The mechanism how it happens is that whenever a beneficiary registers himself or herself into the Swalambhan card, that portal, which is the portal issued by the registered by the Government of India, Lordship, the data which are put in by the beneficiary, those are shared with the local district medical authorities. Now, the evaluation of that patient has to be in front of the local district medical authority. Now, whatever the quantification that has been mentioned in while making the application, and whatever quantification it actually finds out during the evaluation, that may varies, and that other authority, the district medical authority, are the concerned ones who has to upload the latest figures, and based on the figures or the evaluations.
So who can operate the data? Or
the certifications has to be made by the local district level authorities.
The board will certify.
Board will
got
certify.
a certificate saying 90%. How can he amend the certificate from 70 to 90? You tell the procedure.
Those procedures are being, in fact,
you get some written instruction on that aspect.
There has to be some clarification. We cannot make any submission from the bar. There has to be some clarification as to how this is entered, feeded in the portal. Previously, if I obtain a disability certificate with 50% disability, subsequently it has increased, then how can I, in my disability card, I can increase it to 70%?
In
This
cases
is a progressive.
This is just like amendment of my
in
disability.
cases, it has been found out that while making the application, a patient has mentioned 50% disability, but while at the time of evaluation it came out to be 30% or 35%. So then that
No, correct. You are right. The evaluation will be done by the concerned board.
concerned authority.
If on the date of evaluation, if the percentage of disability has increased from what it was when application was submitted, that data should be entered. You tell the procedure. Because this is a progressive illness. So that nobody can dispute. A person cannot come back to square one. A person with 70 cannot become 30.
Yes.
It can become 80 or 90
Yes.
or 100.
Certainly.
In fact, in the MAC claims also, this is one of the aspects which is taken care of. Progressiveness. Like in future prospects, he can't work. So if suppose he is suffered such a fracture, over a period of time, his productivity will rise, loss of earning capacity, those are all new heads were there. One more aspect, sir, please take note. One more aspect which has been highlighted is with regard to the disability certificate which has been issued. In particular, the percentage of disability. One of the parent of a child suffering from muscular dystrophy is present in court, and it is submitted that he had filed an application for issuance of certificate in the portal in the year 2020, and certificate was issued in 2025 certifying that his son is 70% disabled. However, the board, appropriate board which examined him as on date, has certified that he is suffering from more than 90% disability. This aspect of the matter has to be taken note of by the appropriate authority, since muscular dystrophy is a progressive disease, and therefore the percentage of disability is bound to increase. Therefore, the learned additional solicitor general is requested to get appropriate instruction as to how the portal can be, how the percentage of disability as and when it increases can be uploaded in the portal. And the procedure to be adopted in this regard may be furnished, preferably in a flow chart format. It is made clear that such amendment of the percentage of disability can happen only after the appropriate medical board certifies the patient to suffer from a particular percentage of disability. And based on that certification, the information available in the portal has to be amended. The appropriate authority of the Government of India may give necessary written instruction to the learned additional solicitor general in this regard. So we'll have it after 2 weeks. By then, she will obtain that invoice pro forma, this uploading. That center of excellence for the present we are closing.
That part is over.
And we have suggested 3+2 ICU beds, 3 for muscular, 2 for other rare disease, plus other medicines along with the cortisone.
With the cortisone, with the steroid.
Steroids to be supplied on for a 2-month basis.
Lordship, that
wheelchair, my lord.
Purchase of wheelchair also.
Most importantly, my lord, 5,000 rupees off.
Yes, 5,000, because
I'll come back.
They have been saying that they have to have.
Madam, you tell that court requested madam to.
I'll be showing her this.
The physiotherapy is becoming very expensive. It is required for 5 days at least a week. So that money will be utilized mainly for physiotherapy. That is becoming a.
5,000 is also very less for physiotherapy.
But at least it will be a beginning.
Is for them to take the children to the center is difficult for physiotherapy. For a normal person, he can take an auto or a toto, or even when taxi, he can go. Right. But to transport these children, it will be a big torture for them also. Once in 2 months, they visit the hospital, that is fine. Every day for the parent to take them to the physiotherapist. But one thing, madam, you need equipment. No?
Yes.
So unless you take.
No, they are.
Dystrophy children, like for physiotherapy, is very soft. Like they cannot move.
Yeah,
they cannot give pressure. Very soft. Like they have to move. Like we do when we were in school. We used to do PT. Like this, hath upar, and like this they need to do. But that.
Then what we can do is we'll shoot a short film on video. Give you that so that you can play that in your TV at home and ask your
that
baby
COE
to do.
does. Like when they visit the physiotherapist in COE, they show the parents how to do the physiotherapy. They go back and
no, if it is prepared in a video form.
The children don't want to do it under their parents. That's the main.
Every day doing that physiotherapy is also a strain for parents, because every day. So regularly doing, and children doesn't also want to do with the parents. And sometimes they do, like they take the video and do at home, but sometimes it's not also like proper. But they are not
trained, is very important.
Trained, because sometimes they apply a full pressure and the like the legs gets bent. because their bones are very brittle because of steroids. They take steroids. The bone has become very brittle.
So your calcium supplement should increase.
Yes, that
But
is
that can also be dangerous when then they will develop stones. It's very difficult.
It has to be monitored. Mainly monitoring is very important. In that connection, Your Lordship, they were saying that till now, the Center of Excellence accepts these patients for treatment on Wednesday. They were saying if it could be done twice, because all rare patients come on that particular Wednesday. So if it's given at least twice a week, that would be very helpful.
Wednesday or and Friday.
Any 2 days.
No, the OPD functions.
At the moment, it's the only center for rare disease in Eastern India. So there is a pressure on if it's done only on a single day.
No, this OPD is conducted only on a single day.
Yes.
OPD?
OPD 2 hours for 2 hours, 11 to 1 p.m. And
on an average, there will be at least 30 people, no?
Yes, not 30, at least 10 people, but they have a lot of issues now. Ye test, wo test.
So that's why they're saying that if it could be done twice a week.
One more suggestion, which has fallen from one of the parents of the children suffering from muscular dystrophy, is to conduct the outpatient, is to keep the outpatient department open in the hospital for treating patients with rare disease on 2 days a week instead of 1 day, as is presently being done, as the pressure on the medical faculty is also more on that particular day. This aspect may also be considered by the appropriate authority of the state government, and a report in this regard shall be.
You have been given suggestions.
But if you can get to one, at least one, Mr. Bishuru, why can't you get one of the Chamber of Commerce? You've got so many friends here.
Contact with
one person, if you get, we'll get those 20 wheelchairs. She's saying only 1,000.
I think your best thing is subject to correction.
We have issued.
Kindly issue a notice on ILS. Then Mr.
Maurice Sena has been very.
Now,
how to issue a direction? You talk to him. In fact, we have made them parties, no? Dityesh, we issued notice to all the on what date we issued. Do you remember the date of the order, madam? The date of the order where we issued notices to all the
solicitors.
All the Chamber of Commerce.
That's solicitors.
Ninth of May.
আমার কাছে অর্ডার আছে আমার বিফটা একটু দেখি
On 7th March 2024, Your Lordship had passed an order.
May 2024.
9th May 2024.
Again on 2nd May 2024, Your Lordship had passed orders. Lordship.
By our order dated.
Lordship, there are 3 orders. 2nd May, 5th September, and then again 9/5/2024.
No, in the 9th May order, we directed registry to send notice.
Lordship.
Sent it.
And it was sent.
By order dated 9/5/2024, this court directed the registry to send notices to the various Chamber of Commerce, requesting them to give their views and suggestions as to whether the members who are corporate houses are willing to contribute a portion of their CSR exclusively for treatment of patients suffering from rare disease in state of West Bengal. The operative portion, the relevant portion of the said order dated 9/5/2024 is quoted here and below. Para 14, 15, 16 and 17. It is the court has been informed that notices have been served. However, none of the Chamber of Commerce have responded. We would request the learned advocates appearing for the petitioners to inform the councils who are associated with the Chamber of Commerce or who are advising corporate houses who obviously would be members of the Chamber of Commerce to extend a helping hand to the persons who are suffering from rare disease. During the course of hearing, Mr. Shivshankar Banerjee, learned advocate, has expressed desire to sponsor 5 wheelchairs. He's here.
Okay.
They said the submission is placed on record and will be taken into consideration when orders and directions are issued in this regard. Shivshankar Banerjee, learned advocate, within bracket, mobile number 98302 13870, bracket close. So when shall we have it, sir?
Lordship has said 2 weeks from now.
You give a date.
No, Mr. Sinha is here. Just formally, I have requested him to just attend. Muscular dystrophy
No, Mr. Sinha, one second, please come forward. This is actually a set of public interest litigation, which at least I have been here for almost 3 years. We are doing from time to time concerning persons suffering from rare disease, especially muscular dystrophy. The parents of some of the children are also here. Time to time, various directions were issued. There is a lot of funds crunch. So what our suggestion which came was, when myself and just Hiranmay Bhattacharya was there, whether some of the corporates can earmark a particular amount of their CSR for this purpose. They can put the money into the government, or they can sponsor like 50 wheelchairs, this equipment, BiPAP equipment. So then it struck me that it's better we implead the Chamber of Commerce, not implead, put them on notice. So then we got a list of Chamber of Commerce. I think Vishwarup only gave the list. About 22 Chamber of Commerce are there. Registry issued notices to all of them. All of them received the notices.
No one has responded.
9th of May 2024, 2025.
24.
29th of May 2020. If you can use your good offices.
At least 3 Chamber of Commerce, I can ensure that.
Tell Bharat Chamber of Commerce that's sufficient.
Bharat Chamber of Commerce, Bengal Chamber of Commerce, and there's one BNCCI. These three,
and what we'll do one thing, they will give you copies of those 3 orders and today's order also.
Yes.
So we will not record anything today.
I'll ensure this.
You take the copies and then please help us out.
মাঝখানে ফোন করেছিল council কে appear
Memo numbers, sir.
Yes, but I'll
10th July, the notices were served. Memo numbers are also here.
Notices have been served, and this is evident from
10th July 2024.
the report of who's the report?
No, this is the order. This is the order on the basis of the from the section.
So record
central dispatch.
A report has been submitted by the central section of the central department. We can have it on 15th July, sir.
কিন্তু in the main আমরা চাইছি CSR
My lord, another 5 by him, another 10 by him, so 20 is
all right. Then Shivshankar Banerjee. Then in that you add Mr. Vishwarup Bhattacharya, learned advocate, who in fact represents one of the petitioners, has volunteered to sponsor
that he is doing, but
5 wheelchairs. And full stop. Mr. Prithyosh Sinha, Secretary, Learned Advocate and Secretary of the Incorporated Law Society, has also agreed to sponsor 10 wheelchairs. With this sponsorship, 20 wheelchairs can be purchased, and as directed above, the parent of one of the children suffering from muscular dystrophy shall obtain a pro forma invoice.
Yes.
Pro forma invoice from the concerned company, which is supplying foldable, affordable wheelchairs at affordable cost. Don't no, madam.
Fund requirement is how much?
Enormous.
So don't tell them that for court purpose they want the pro forma.
No.
Get scared.
They'll
Don't
get
give.
Yes.
As if she wants it.
That is an impossible. That's in crores.
For that.
Manual operated. He says the karma engineering or something is there. 1,000 rupees or 1,500 rupees will be the cost.
Doshad, I saw the price 10,800 in the.
So if she can get a pro forma invoice, based on that we can place an order. So list the matter on 15th July. So Sinha, if you can be here on 15th July, it will be helpful. If you are available here.
But if I'm in Calcutta, I'll definitely be here. There's a possibility I may not be in Calcutta, but if I'm here, I'll definitely be here. Could it be not just a week thereafter, not just 15th or
22nd?
I'm very grateful.
22nd.
I'll definitely be.
We're very grateful to your lordship.
Yes, sir.
Great.
Serial number 4.
My lord, in serial number 4, the learned advocate, who is the advocate on record, my lord, is indisposed. My lord, so he has not been able to come to the court. But I'm praying for not this week. Let the matter be taken up on coming Monday. Next Monday, my lord. Let it be so.
Submitted that the learned advocate for the appellant is indisposed and adjournment is sought for. List the matter next week under the same caption.
Same caption, Monday. Grateful, my lord.
Thank you.
Much obliged.
Serial number 5.
I'm for the appellant here.
Delta. The moment I saw this name, I knew.
Lordship,
I think their business is more in the High Court than outside.
Your Lordship, the main issue over here was that the main form the respondents are not there. I'll serve notice and come back, Your Lordship.
And the report says that some defect has to be
I'll
rectified.
clear the defects, Your Lordship. Leave me be
The defect pointed out by the registry shall be rectified within a week, or within 2 weeks. And in the meantime, notice shall be served on the respondent, as well as the learned advocate who appeared for the respondent before the single bench.
Serial number 6.
Respondent. Appellant is not there. Oh, they said it is merged with two rural banks.
That can be passed by you. They have filed an application also.
That we will order today. What is the CAN number?
CAN number.
Sir, CAN 2 of 2025,
Yes,
you please give.
My lord.
CAN 2. Here.
Lordship, Mr. Bodhuria Ghoshal appearing in the court number 19. Kindly give pass over.
Not pass over, it is already 3:45. Today we will order the substitution application.
Government bank. Supposed to be notice of in the first notification by the Minister.
So page 9 of the application is the notification. It's 5th April 2025.
A new bank form.
A new bank form.
Can 2 of 2025.
This
application has been filed by the appellant for substitution new name of the bank instead of the old name as given in the cost title on account of merger which has been notified by notified in the Government of India Gazette.
Page 9.
Dated 5th April 2025. Intimated through public notice as well. Accordingly, application 2 of 2025 is allowed.
Issued by the
and who will do the substitution action? And the learned advocates go to the department and do it. Department will do it. And the department is directed to substitute the new name of the bank, namely West Bengal Gramin Bank.
The public notice at page 12. Page 12 is the public notice.
That also you are. And in the place instead and in the place of Paschim Banga Gramin Bank. Application allowed. This is the matter next week.
And 2 is disclosed.
Good.
Number 7.
For the respondent. Which respondent? Respondent one.
In terms of your lordship's last order.
It is returned.
Yes, they have received one not served. But the contention of the appellant would be that the order of the single judge was, so far death benefit is concerned, that is to be divided amongst 3 heads and writ petitioner service may be considered. Now, the facts which laid before the learned single judge and also before your lordships are absolutely disputed questions of fact, so far legal errors are concerned. What happened over here is writ petitioner claimed that he is the son of the employee who died. 2 sisters, they gave no objection. He claimed that his mother died in the year 2002. After he claimed his employment as well as compensation, one lady sent a letter, submitted a letter with ECL authority says, I am the deceased wife, I never died. So who would determine this question?
No, that lady, he says.
His mother, he claimed his mother died in 2002.
But the mother says, I am still alive.
Yes, in 2017, his mother wrote a letter, Girija Devi, wrote a letter to ECL authority, don't give anything to this writ petitioner.
Ask her to appear before your officer.
My lord.
See, somebody sends a letter that he is alive.
He said, it is he who submitted death certificate, who submitted documents.
Person is dead.
Now, ECL sent this whole gamut of facts to district magistrate to verify. District magistrate did not come up with any kind of inquiry report.
Why?
We waited for that. It's a long drawn process. In the meantime, he preferred this writ petition. Now, the second aspect.
No, sir, one thing, sir. Death certificate is a public document. There is a presumption attached to its validity unless
7 years under Evidence Act.
Evidence Act.
Absolutely.
But that certificate, unless proved to be false, it continues to hold the fee.
Absolutely.
So you ignore that letter. Why are you concerned about that letter? That lady has not walked into your office and said, I just...
Yes, the lady came, she submitted that letter in person.
All right. How do you know that she is that lady?
That is why we sent it before district magistrate to determine, to verify.
It is a claim which has not been established. The onus is on her to establish that she is the person who's not dead but alive.
My lord, we have not yet received that conclusive report, whether Girija Devi at all died or alive. Now, the second aspect, he said his mother is the only wife. No, there is a second wife. He suppressed all through.
Second wife is not a legal marriage.
Not second wife. I am on the sons of second wife. They are legitimate claimant.
They have not received notice at all.
Yes.
They are not appearing.
That is the difference.
And what is the direction issued by the court?
3, to divide the sum accrued in 3 heads and to consider his job.
3 heads means?
That is the
3 portions.
I don't know.
But
This is not very clear.
one thing.
Page 136 is the order.
The deceased employee.
You read that concern relevant paragraph, sir.
Page 136 is the order.
We have got the what is it?
The deceased employee had 1 son and 2 daughters. The learned single judge directed
the finding of the learned single. Relevant portion of the order.
My lord.
From the certified copy. Page number.
136 is the impugned order, my lord.
Internal page number.
Internal page number, my lord, 6.
No,
page 5.
In the upper
facts and circumstances, the respondent in particular ECL is directed to compute the terminal benefits available to the deceased employee immediately upon his death. The computation should be completed by 30th October 2024, and a copy of such calculations should be forthwith made over to the petitioner for his consideration. 1/3 of the share of such benefits should be given to the petitioner with interest, accrued interest of 6% simple interest per annum from 23rd April 2025, date of death of employee, till actual payment. The interest is allowed as the petitioner was deprived of his benefit of the money while he still earned benefits thereon for the said period. The entire exercise of paying 1/3 share along with the accrued interest from the date of death of the employee 22nd April 2015 shall be completed by 30th November 2024.
Yes. Then what about the remaining 2/3?
So what?
Nothing has been done.
We are questioning this issue of 1/3 share.
Correct.
We have Girija Devi, we have his 2 brothers and this person. So it should be 1/5. Second wife, 2 sons, and another wife.
Sir, so far as compassionate appointment is concerned, ECL shall within 3 months of the date take a specific decision whether the petitioner is entitled to.
Yes.
You take a decision this way or that way. And this is a very balanced order. In any event, Girija Devi has to prove that she is still alive. That verification process is yet to be over. That is why your interest has been safeguarded. Only 1/3 to be disbursed. If those 2 fellows, 2 sons, they wake up and come, it's up to them. Then in another 1/3 share is there. You divide it into half and give it to them.
Yes, and that's what fallen from your lordship is we are concerned of the complicity that would ultimately arise because of these disputed questions of fact. We will face the predicament.
We will protect you by directing him to file.
I don't want anything. I need only this protection from your lordship.
Yes,
that's all.
We will do one thing.
As my lord, kindly recall what I said on the other day. My challenge is to seek modification. I'm not challenging the whole.
What we will ask him to do is to file an indemnity bond.
Absolutely.
In the event there is any other claim which may touch upon the 1/3 payment.
Absolutely.
Or touch upon his eligibility to be considered for compassionate appointment, he will be solely responsible. ECL will not be responsible.
Absolutely. Grateful.
If your lordship kindly takes up page 123, that is the service book.
Sir, your mother is alive, sir.
No. That's what I'm coming to, my lord. My lord, it is my mother. I know very well when she has died. My lord, the annexure is at page 62. The death certificate of my mother. My younger brother died first in 1999. My mother died in 2002, and my father died in 2015. Now, my lord, I had applied for compassionate appointment. My lord, if your lordship kindly takes up the Page number, my lord, 123 is the service book. Now, my lord, in that, if your lordship kindly takes, 125 is the particular of the family. Here, Girija Devi, Dinesh Roy, and Dilip Roy has been mentioned. Now, my brother has expired.
When did what is the petitioner's name? Dinesh Roy.
Yes, my lord. My brother has died in 1999. The death certificate is annexed here with, my lord. My mother died in 2002, and my father died in 2015. Yes, who was the sole bread earner. Now, I had two sisters who are married now. Now, I have disclosed that. Now, my lord, thereafter, my lord, in 2016, I filed my application with the authorities to grant me compassionate amendment. Since 2016, they have carried on medical test has been done, scrutiny has been done, and now, my lord, in 2019, they come up with an application that there is one Girijwa Devi who is claiming to be a mother. Now, for that, my lord, we had also written to them, if there is any, you conduct a probe, you are an authority, you conduct a probe, they remain silent. Now, my lord, from 2015 to 2025, my lord, I have been made to run from pillar to post. There is no payment. There has been no progress of.
Please show where that medical and other things were done for your compassionate appointment.
But if your lordship kindly takes up page 75. Here, my lord, point 2, my lord, they have acknowledged that 7/4/2016, page 75, my lord.
75.
Of the stay application.
Yes.
My lord, point 2, my lord.
Allow court to
As per your.
They have acknowledged that 7/4/2016 is my date of application. Since then, my lord.
It starts with there are 5 dependents. Kindly see point number 1.
No, my lord.
Page 75.
Sir, to bole din, sir.
Page 75, point number 1. There are 5 other dependents of late Suresh Rai, 2 daughters, 2 sons, 1
Service
wife.
book is to be held conclusive, my lord. Service book is held to be conclusive. Now, in that, my lord,
that is also
The
disputed.
wife is some Lalita Devi.
Lalita
that
Devi
is
is
a
the second wife.
question for which we had written to them. You please conduct a probe. Number
page.
My lord, coming page.
He,
My lord, page 76, we had written to them.
my lord, kindly take note of page 121.
Point 1.
We had written to them elaborately.
What is this Anchal Adhikari?
Anchal and Adhikari is block officer or something of that sort.
Block officer.
And block officer, why he gave that communication? All right.
Now,
where is
my case is at rest at page 75 is my case.
Why have you not considered him for compassionate appointment?
If ECL is protected, I have nothing to say.
No. ECL will protect. We'll issue a direction to give him compassionate appointment.
Grateful.
If he is given, my lord, he is saying service book. Lordship, kindly take up service book once, page 124.
I hereby certify that the particulars are
Page
correct.
124, kindly see the last right hand side, your lordship's right hand side. The date 23/4/1991. His date of birth, my lord, is 1/1/1992. At page 127 is his date of birth. Kindly see. He is relying on service book.
But this is their document. my
Service
lord.
book is also disputed. All
This
these
is
dates
their
are
document, my lord. This is not mine. And my lord, 17, my lord, says that
kindly
in
see
case of
page
death of the
124
employment,
and kindly consider page 127.
But in case of death of the employee, I would be getting the compassionate. That is their service book. That is maintained by them. That is not my copy. I am not the holder of this.
Whether service
But your Aadhaar card says your date of birth is 1/1/1992.
But based on that, they have a policy. They have a policy to grant me compassionate. They were sitting idle for this last 10 years.
We are perplexed because of all these disputed
Wait, sir,
questions
wait,
of
sir.
fact.
Mr. Vice President, please keep quiet. Now, if your date of birth is 1/1/1992, in 1991, you could not have been 10 years.
That is a magic mullet that could have happened.
But one thing, sir, you have to take. He was a loadsman. At that time, there was no conveyor belt, etc. Fellows,
Absolutely.
they'll be fully soaked in coal dust. They'll be so much. Lot of people die very prematurely because of the lung infection, both in coal mines and mica mines. Mica, the longevity is not more than 35. Now the latest thing in mica mines is small girl children. That's what they said in one conference, because they require small passages and only the small hands can reach inside. And invariably by the age of 12 to 16, because of the poison, they don't have all the wherewithal washing these hands. All right, sir, please come. This intra-court appeal by the Eastern Coalfields Limited is directed against the order dated 1/10/2024, by which the writ petition filed by the respondent Dinesh Roy was disposed of, issuing certain directions. The appellant ECL appears to have not be fully agreed with the directions, but they are apprehensive of the repercussions that may occur after the directions issued by the learned single bench are implemented. After elaborately hearing the learned advocate for the appellant, we also opine that the apprehension of ECL is not wholly unfounded on account of certain discrepancies in the records submitted by the writ petitioner seeking compassionate appointment as well as compensation on account of the demise of his father, Suresh Roy, who was employed as a loadsman in ECL mines. One aspect is that the first apparent it appears that Givija Devi, Givjaw Devi, who stated to be the wife of Suresh Roy and mother of the writ petitioner, is said to have submitted a representation stating that she is not dead but alive. In this regard, ECL has commenced an inquiry and requested the district magistrate to cause necessary inquiry. However, till date, no report has been submitted. It is not in dispute that, according to the writ petitioner, his mother died in the year 2002, and to establish the same, death certificate has been produced. Till date, the death certificate has not been cancelled or annulled in the manner known to law. Therefore, it is presumed to be valid and to be accepted by ECL as a document reflecting the correct and true particulars. The other aspect, apprehension is on account of the number of legal heirs for the deceased employee. Considering the claim made by the writ petitioner, the best document which can be referred to is the service book of the deceased employee Suresh Roy, which shows the names of only 3 persons, namely the wife Givja Devi, the writ petitioner Dinesh Roy, and his brother Dilip Roy. It is the brother of the writ petitioner Dilip Roy passed away in the year 1999, and death certificate has been produced. Considering these factors and also bearing in mind that the interest of ECL also has to be protected, the learned single bench had directed payment of 1/3 of the share in the compensation together with interest at 6%, together with simple interest at 6% per annum from 23rd April 2015, namely the date of death of the employee, till actual payment. With regard to the request for compassionate appointment, direction has been issued to consider the same. With regard to the status of the request made by the writ petitioner for grant of employment on compassionate ground, the request is lingering from 2015. 2016. By full stop. By letter dated 12/12/2019, the writ petitioner was informed by the deputy manager of ECL, pointing out certain discrepancies, for which the writ petitioner has submitted a reply. Stating about the demise of his mother on 18/5/2002 and his brother Dilip Roy, and the demise of his brother Dilip Roy on 28/2002. And the two sisters have also given no objection. Further, the writ petitioner referred to the service record, wherein his father has given the name of the dependents. And with regard to the claim of one Lalita Devi claiming to be the second wife, has absolutely no basis. And that Lalita Devi is not Girjua Devi, and it's a false claim. And requested his explanation to be accepted and employment be provided. Till date, no valid claim has been made by the said by Lalita Devi, and the allegation that the mother of the writ petitioner is alive as on date has also not been established and proved in the manner known to law. Therefore, we are of the view that the appellant should comply with the direction issued by the learned single bench to pay 1/3 of the compensation together with the interest fixed by the learned single bench within a time frame. With regard to the request for compassionate appointment is concerned, if the interest of the appellant ECL is safeguarded, then the appellant should not have any apprehension in granting compassionate appointment, which will be subject to an indemnity bond being executed by the respondent writ petitioner, indemnifying ECL from any claims whatsoever which may arise in future, either towards the part of the compensation paid to the writ petitioner or to the compassionate appointment that is to be provided to the writ petitioner. Accordingly, while affirming the direction issued by the learned single bench to pay 1/3 share of the terminal benefits / it's not compensation, terminal benefits.
Terminal benefits.
Retirement benefit. Compensation, you put terminal benefits. Terminal benefit together with interest at simple interest at 6% per annum from 23rd April 2015 till actual payment. The appellant, the writ petitioner shall also be given compassionate appointment in a post commensurate in an entry level post, and the above two directions shall be complied with within a period of 2 months from the date on which the writ petitioner files an indemnity bond. The form of the indemnity bond shall be settled and drawn by the appellant ECL, and the appellant shall, and the writ petitioner shall execute the indemnity bond in the said format duly stamped, and upon submission, the 1/3 of the terminal benefits shall be disbursed together with the interest, as well as the writ petitioner be provided an appointment on compassionate ground. It is made clear that both the above directions will be subject to any claims that may be made by any third party for as against the benefit granted to the writ petitioner, and in the event of such claim, ECL shall not be held responsible, and the writ petitioner alone shall be fully responsible, and ECL shall be indemnified and kept indemnified perpetually.
Your Lordship kindly takes note of the pages 69 and 70 where the medical test was conducted. Page 69 and 70.
Compassionate grant, compassionate grant. 69.
69 and 70. Medical test and screening was done of the petitioner.
Furthermore, we also find that the medical test and screening test has also been completed
in 2017
as early as in the year 2017, and this could be seen from the documents annexed in page 69 and 70 of the state petition.
Grateful.
This postum. Here you say notice sent to the respondents returned answer unclaimed.
Thank you. মামলাটা এমনি আমাদের একেবারে বিরাট না, আমার খালি প্রোটেকশনটা ব্লক হচ্ছে।
Next.
হ্যাঁ, এই মোটামুটি তোরা
Lord, I appear for the appeal. Lord, there is a delay of 82 days in filing the appeal, my lord.
Notice served?
Yes, sir, my lord.
Affidavit of service?
Yes, my lord. By hand as well as by post.
Last occasion, Mr. Partha Ghosh appeared for the Union of India. None appeared for the appellant.
My lord. On the last occasion.
That was on 19th June.
Well,
Sir, Diptesh, check the affidavit of service. But can you, all right, we'll condone the delay.
My lord.
But can you inform?
My lord.
You will inform him now. We have heard so and so, so and so.
Much obliged.
There is a delay of 18 days.
82.
82 days in filing the appeal. We have perused the affidavit filed in support of the petition, and we find that sufficient cause has been shown for not preferring the appeal within the period of limitation. Hence, the delay in filing the appeal is condoned. Application allowed. Next week for admission.
Much obliged.
Number 9.
One of the applicant. There's a short point involved in this appeal, my lord. CPF to GPF. My lord, the delay, my lord, the writ petition was dismissed on the ground of delay. But my lord, public sector, my lord, in a public sector, my lord, the public sector's institution, my lord, the central government issued an order, issued a circular wherein that if any employee, my lord, join on or before 95, my lord, they can allow. In 2019.
But this is irreversible, sir. Now it can't be. You can't set the clock back. Once you have opted for CPF, you can't roll back for GPF. Now that scheme is not available. And now everything is automized. In fact, this happened to judicial officers also. And as a single judge, I allowed the petition. Division bench confirmed. Supreme Court reversed it. Because a cutoff date, that is why a cutoff date is fixed. Suppose there is a genuine mistake. The option form contains, let us say, 3 paragraph 4. This man has read only first paragraph, and in that first page he has signed. The last page he has not signed. Something has happened. Some mistake within the short period, rollback was possible. But now it is impossible.
But the delay, is the public kindly see that is though there is an insurance company, government 295 on or before.
But after 23 years, he is enjoying this CPF.
With interest. I refund with interest.
It doesn't work that way, sir. It doesn't work. Now, after everything is automated, it doesn't work. The portal will not accept. And now manual files, everything is gone. 23 years. What is his age now?
Age 84.
Let him be happy. You tell,
But
we'll
due to
dismiss the appeal.
my
You
wife.
tell him that appeal is still pending.
Only for my wife.
4 times he exercised option to continue in the contributed. 4 times.
See, the thing is, sir, what was he working as? What post?
A post.
What was the post he was holding?
Assistant.
Service of
Section officer.
Section officer, then if he is a group D or something, you can tell. Section officer, he only makes the note. Up to the general manager, he only makes a note.
Qualified.
In fact, section officer will know better. You ask my ladyship, they know everything. How to put up the file, what is, how to flag it, what has to be sent. When you prepare reply to government, how it has to be addressed. This intra-court appeal by the unsuccessful writ petitioner is directed against order dated 9/12/2024. The petitioner, after opting for the contributory provident fund scheme, retired from service after 23 long years. Now filed the writ petition seeking to change his option and seeking to be governed under the General Provident Fund scheme. The learned single bench took into consideration the factual position and more particularly the delay and declined to grant the relief sought for. We fully concur with the view expressed by the learned single bench, not only on the ground of delay, but also on the ground that the writ petitioner, appellant writ petitioner, had exercised his option not once but 4 times, opting for contributory provident fund scheme. Hence, we find no grounds to interfere with the order passed by the lands. I think if there is a delay, please condone. Delay condoned, appeal dismissed. Next.
Number 10.
Ziaul Haq.
I will take on behalf of the appellant.
Lord, I am for the writ petitioner respondent, my lord.
Lord, there is a delay of 123 days.
No
Lord,
problem.
I have explained the delay in my section 5 application that the order page 6, my lord.
But last time you wanted
No,
some affidavit
yes,
in opposition
opposition, my lord.
for the delay.
For the delay.
You are vehemently opposing.
Yeah, my lord.
What is the matter?
Because my lord, the petitioner is suffering, my lord, since 2020, my lord.
My lord, this
There
is
was a order for the opposition in the year, my lord, 2022. They did not file their opposition in the 2024 also. Thereafter, the order is passed, my lord. My lord,
my lord, the delay is only 123 days, out of which 43 days has been, my lord, the communication ex parte order. Communication was made after 43 days.
And what is the age of retirement? 60.
60 years.
What
My
is
lord,
the present
my lord,
age?
the case is there here. He was engaged as, my lord, the casual worker for 6 months only in the year 2002. Thereafter, my lord, regular post was created in 2010 and regular post was duly filled up. Suppressing that fact, he has come forward before.
The problem is you did not appear before the single
My lord,
bench.
my lord,
So you should first seek for recalling that order. See, you want us to test the correctness of the order
my lord.
based on certain facts which are not on record. This fact which you are saying,
my lord,
she was appointed only for 6 months, contractual. Thereafter, post was created, filled up by the following.
It's a regular
But
and that has been suppressed.
Petitioner engagement order is till 2019 on from the 2002
what we'll
to
do
2019.
is, if you file a review before the, that is the only this appeal has been preferred by the state, challenging the order dated 13/9/2024, by which the writ petition filed by the respondent herein was allowed, issuing certain directions. From the impugned order, it is seen that despite direction being given to file affidavit in opposition, the state did not file an affidavit in opposition, and they did not appear.
They did not appear. Thereafter, one day the matter was called. The advocate for the state was communicated.
And did not appear.
In my
And
opposition, I am given the letter also, my lord.
Based on the available material, the learned writ court has disposed of the writ petition. The learned advocate appearing for the appellant state has placed certain facts to state that the impugned order, that the direction issued in the impugned order is not feasible of implementation, since the writ petitioner was given contractual appointment for only a period of 6 months, and thereafter the post which was sanctioned was filled up by following the recruitment process. However, this aspect was never brought to the notice of the learned single bench, and we cannot test the correctness of the order passed by the learned single bench on the basis of the facts which are now placed before this court in this appeal for the first time. Therefore, the only option available to the appellant state is to seek for review of the order before the learned single bench, subject to the order. So, accordingly, the appeal stands disposed of, leaving it open to the appellant state to seek for review of the order passed by the learned single bench, if they so decide.
One liberty, my lord, the certified, my lord, may I be get back the certified copy, my lord, from the
My lord,
the original certified copy of the impugned order be returned.
my lord, my lord, kindly record my submission that petitioner is working not for the 6 months, more than 6 months, and
Before that, the learned advocate appearing for the respondent submitted that the stand taken by the state government that the writ petitioner is working only for 6 months is factually incorrect, as she has been working for several years.
No, 7 years. Normally, from 2002 to 2020, almost 18 years. Almost 18 years.
At a time, 6
For
months.
nearly 18 years. Next.
Serial number 11.
Deeply problematic.
Supplementary affidavit.
Writ petition has been annexed in the supplementary affidavit. Writ petition has been annexed.
Your Lordship, the annexures to the same, and this is my affidavit of service.
What is the matter?
Your
Widow
Lordship,
of the employee died in harness.
in 1995, the employee died. From the documents, it appears that the application was made back in 1996. Defects were notified by the appellant to the in 1996, April 1996. They did not clear the defects, so we gave a reminder in 1998 that in spite of the application filed long back, we have notified that 1996 defects were there. The same were not cleared. Thereafter, Your Lordship, screening committee, she was directed to appear before the screening committee on 28th February 2096, and discrepancies were pointed out, which is at page 10 of the supplementary affidavit, which is at 28th March 1998, Your Lordship. What are the discrepancies? The identity.
But then you rejected the claim only on the ground of delay.
No, Your Lordship. We rejected it on the ground that two different, in the gratuity at page 10 of the supplementary affidavit is the discrepancies pointed out, Your Lordship. Death certificate stated different dates of the deceased. Your Lordship, typed copies at page 10A. Reference to your application for payment of monthly maintenance allowance of 2,000 in lieu of employment against the death of your husband, late Doba Bhora. We are to inform you that the above proposal was sent to competent authority, who returned back to this office with the following discrepancies detected and invited to rectify the same. Death certificate, late Bhora, has not been submitted by you. Relation certificate is in order. A fresh relation certificate is needed. Home address different in different address records, and address has not been indicated in column 6. It is mentioned Doba Bhora expired on 10th March 1997, but as per our records, it expired on 24th of January 1995. Please confirm accordingly. As per the service experts, the name of late wife of late Bhora is Rama Bhora, whereas one Manorma Bhora is claiming monthly maintenance. Allowance confirmation in this regard is needed with supporting papers. Reason, justification for delay, submit your claim of maintenance allowance in new format available. Your Lordship,
next page, 11. His reply.
Your Lordship, before that, Your Lordship, the identity of the petitioner itself is it, we have questioned that, because as per our gratuity documents, Rama Bhora is the person who is mentioned in our gratuity papers.
Rama Bhora.
But
she is otherwise known as Monorama
but
Bhora.
no supporting documents have been given.
How
Even,
it will be? When this Mono Bhora was born, probably born in 1947.
Your Lordship, she has submitted
And
an
not a single, Amrita, not a single case ECL is honoring this MM.
Your Lordship, page 4 of the
Today morning, we have delivered a judgment authored by a Lordship. You read the judgment. You have quoted all the, in spite of being unsuccessful up to the Supreme Court, you are still beating these fellows black and blue.
Page 4, Your Lordship, is the affidavit submitted by her.
No, how?
In page, Your Lordship,
No.
Your Lordship, page 4 is the affidavit. In 1998, she says that she's 44 years. In the writ petition in 2024, she says she is 65 years. Whereas, if the calculation, there's a 26 or 27 years gap, so she should have been 71 years. So her own document shows that there is age discrepancies that have been given by her.
Do now.
Your Lordship.
And what was her husband doing? Loadsman.
Your Lordship.
Load.
And our prayer was before the learned single bench that police verification is required. Before that was also.
Police have got better things to do, madam.
Your Lordship, a 3-man committee is formed for comprehensive verification. Police verification and a 3-man committee is formed before any MMCC is released, Your Lordship.
In fact, there is one decision of Eastern Coalfield itself where it says it's a continuing cause of action and the question of applying limitation, etc. will not arise. Number 2, he has produced certain documents. Asansol municipality is given a death certificate. The Pradhan has given a relationship certificate. You prove both the certificates to be wrong. Until you do it in the manner known to law, it remains to be valid. It remains valid. You have to act upon it.
Your Lordship,
and imagine these people going and standing in the DM's office or in the municipality. Do you think they will be brought inside, welcomed, given a glass of water, baitiye, ashram, washram, nothing will happen.
Your Lordship, our case is only
They'll
that.
Be driven off.
Your Lordship, our case is that police verification and they may appear before the
your head office, madam. They can't enter your head office. The security guard will throw her out.
Our prayer over here
Maximum,
is limited to the point.
5 lakh rupees. How much she'll get? 10 lakh rupees.
More than that, my lord, because
32 lakh rupees.
It will be calculated till she attained the age of 60 years, my lord. From the date of the date, that has been decided earlier in so many judgments, my lord. And so far as the limitation point is
that is why rightly the learned single bench says it's also too late in the day for ECL to seek re-verification of documents which have been submitted 26 or 27 years
Your
ago.
Lordship, For
It's not
gra-
expected of petitioner to produce all such document. Even ECL itself has lost track of the document, including the application.
Your Lordship, as per the Act, we are only obliged to keep a document for 8 years, Your Lordship.
No, this is
Preservation of document.
consideration, no?
And we had lodged a general diet.
As per your wage settlement.
Your Lordship, as we had.
Chapter 9.
Your Lordship, we had lodged.
Chapter 9, correct.
Your Lordship.
Clause
9.5.0.
9.5.
One is and 9.5.0.
Your Lordship,
There's a delay. There's a delay.
No, there is no delay, Your Lordship. Our only prayer was that interest may not be levied because of the conduct of the.
You pray that interest may not be increased. Otherwise,
And a police verification may be allowed within the
given,
before the 3 months.
We'll make it 7.5, but you have not filed appeal.
As your lord, as your lord, there are weaker section of the society. Actually, they're coming before us, my lord, through local people of the area. And even then, they are not in a position to come to High Court direct, my lord.
No, they'll be threatened if they go and meet advocate or something. They'll be threatened by the agent. He's called the agent, no?
Yes.
Yeah, the agent is very powerful.
Everywhere there is agent or broker.
Similarly, in tea estates, it's the manager.
Yes. No, Your Lordship, not from agent over here. Our mine has been closed.
No, agent of ECL.
Our mine has been closed over there, Your Lordship. That is the reason the documents are not
powerful. He can do.
No, Your
He
Lordship.
can close the mine with people inside. This intra-court appeal by Coal India, Eastern Coalfields, is directed against the order dated 9/1/2025 in WPA 24137 of 2024. The facts of the case clearly demonstrates that the appellant has been dragging on the claim made by the writ petitioner for payment of monthly monetary cash compensation in terms of the National Coal Wages Agreement on account of the demise of her husband who died in harness while working in the coal mines of the appellant. As rightly pointed out by the learned single bench, what the appellant seeks to do is to re-verify certain documents which were given by the writ petitioner about 27 years ago. And the appellant themselves have lost track of certain documents in their office files. Thus, considering the fact, further we note that the documents produced by the writ petitioner, namely the death certificate of her late husband issued by the Asansol municipality and the relationship certificate issued by the concerned Pradhan continues to remain valid. Therefore, on hyper-technical grounds, the appellant cannot deny the monthly what is it called?
Monthly
maintenance.
MMCC.
Monthly monetary cash compensation within bracket MMCC. Thus, we find that the learned single bench rightly issued the impugned direction, rightly issued the directions as directions, and the same do not call for any interference. Accordingly, the appeal fails and it is dismissed. The directions be implemented within a period of 6 weeks from the date of receipt of the server copy of this. Directions issued with the single bench. Yes.
I'm grateful, my lord.
Number 12.
I am appearing on behalf of the writ petitioner. Yeah, I appear for the appellant. I am led by Mr. Kishore Dotto. He is out of town person, professional.
He's not here.
He's not here. Kindly takes it next week.
It will remain in the list. We'll stop with this.
উঠে গেছে তো বলে দে মেনশন করে দে তুই তো অ্যাপেলেন্ট
মেনশন করো মেনশন
বল
মিলট আইটেম নাম্বার 13 মিলট 13
Next matter, just minute. By an inadvertent mistake, my lord, the respondent number 7, who is the respondent, my lord, in the writ petitioner, added respondent, my lord, was not made a party, my lord, in this appeal.
We'll grant leave.
My lord, leave be granted, my lord, to amend the cause title of the
Leave granted to amend the cause title by including the name
respondent number 7.
Name of the respondent number 7, and such correction made by the learned advocate for the appellant. Let notice be served on the respondent number 7, who has now been included.
Well, 2 weeks time be granted.
My lord, I'm sorry, my lord, I should not, I never do oppose.
But I am representing.
I'm appearing for the primary writ petitioner respondent over here. But most of us have retired long back, some of us have expired. But the added respondent was helping me in the writ petition.
But I am for the
If
added
your
respondent,
worship
my lord, I am accepting service.
He's appearing for
Very
that.
good.
He's appearing.
Then all right. Amend the verse. Mr. Victor Chatterjee, learned advocate, accepts notice for respondent number 7. List the matter next Tuesday for admission.
I'm deeply obliged, Your Lordship.
Next Tuesday, my lord. Ben,